Please, Your Lordship.
Yes.
But I'm praying for listing of a criminal petition, my lord, on Monday, my lord. Some urgency is there, my lord. Today it must come.
Some other courts, senior courts are taking up criminal petitions. You have to mention before the appropriate bench.
Division.
I plead your lordship. Lordship, with due concern from my learned friend, I beg to mention item number 12 here, lordship. Lordship, this matter may kindly be passed over for that day, your lordship.
My lord, we have some urgency in this matter. So my lord, this matter may be taken up on Monday, my lord, along with IA criminal number 1113 of 2023.
Third, Miss
Adeka,
Adeka, learned counsel for the
petition.
petitioner who prays for an adjournment. Also heard Miss
B. Bora.
Deborah, who does not have objection to the said prayer. However, says that due to the urgency, the case may be listed on
Monday, my lord, along
Monday along with criminal appeal.
criminal IA, my lord,
IA.
IA criminal number 1113 of 2023.
I criminal number 1113 number 2023. Prayer is allowed. Let this case be listed again on Monday. On 12th February,
That's it.
along with I criminal number
3 of 2023.
1113 of 2023.
So interim order may continue till Monday.
Order shall continue till next day.
The day after.
May I please, Your Honor? My lord, I beg to mention item number 19, my lord. Kindly pass over for the day, my lord. My lord, in this case, my lord, the brief has been misplaced, my lord. So, my lord, I could not proceed with the case today, my lord.
Heard, Mr.
M. Hussain, my lord, I am appearing on behalf of K. Uddin.
M. Hussain, learned counsel for the petitioner, who prays for an adjournment on the ground that he has misplaced the brief and needs some time to trace it out. Considering the ground, the prayer is allowed. Let this case be listed after a week.
Most obliged.
May I please, Your Lordship? I beg to mention item number 3, Lordship. This matter may be adjourned for today, Lordship.
Lord, I am for the petitioner here, my lord. Otherwise, the matter is pending since 2015, my lord. But
Why are you making
my lord,
adjournment?
his senior has informed me today, requested me, my lord. Today it may be mentioned, my lord.
Okay. Heard, Mr.
P. Telly on behalf of the
P.
petitioner.
Telly, learned counsel for the petitioner who prays for an adjournment. Oh, what is the ground for adjournment?
Some personal difficulties.
Due to
Lordship.
personal difficulty of the conducting counsel. Learned also heard Mr.
A. Chaudhary.
A. Chaudhary, learned counsel for the respondent who does not
Petitioner.
oppose.
I am the petitioner.
Learned counsel for the petitioner who earlier is learned counsel for the respondent. Petitioner who does not oppose the said prayer, hence the prayer is allowed. Let this matter be listed after a week,
Lordship,
Can it
another,
be after 2 weeks, my lord?
after 2 weeks.
Lordship, another prayer is item number 20, Lordship.
Yes.
This matter may be adjourned for today, Lordship.
What is the prayer?
Adjourned for today,
Same,
Lordship.
same. Heard Mr. P. Telly, learned counsel for the petitioner who prays for an adjournment or due to on the ground of difficulty of conducting counsel. Considering the ground, the prayer is allowed. Let this matter be listed after 2 weeks.
It is a Lordship, I'm making a prayer for listing of this IA today, my lord. Yes, day before yesterday, I made a mention, Lordship, allowed by mention to be moved today, my lord, but that was somehow not listed.
This I is for what
My
purpose?
lordship granted the petitioner's bail, my lord, with certain conditions. Accordingly, my lord, we submitted the bail bond papers, but that was neither allowed nor rejected, my lord, saying that certain other conditions. That is why, my lord, we are making a prayer, my lord. I'm deeply
May I pray for listing of a criminal appeal, madam?
on Monday, my lord. Last
No.
time it was on 5, my lord. Then 1 week was given, so it may list on 12, my lord. Kindly.
For what purpose?
I was for bail, my lord.
No, you have to mention.
Last time it was not reached, my lord, on 5th of February. So 1 week was given, my lord. It may be listed on 12, my lord, Monday kindly.
Fifth, it was listed before this court.
Before,
You have to
court may
mention
take-
before the appropriate bench.
no, my lord.
Senior courts are there, taking up same roster.
But my lord, they come on Monday, my lord.
No mentioning before this court.
My lord.
When same matters are taken up by senior honorable judges, you have to mention before the appropriate court.
My lord. Another item, item number 7, my lord. That may be adjourned, my lord. We have taken concern from the other party, my lord. He has informed me through phone, my lord. He cannot come to the post. So it may be adjourned, my lord.
Heard Mr. D. Bora, who prays for an adjournment with consent of the learned counsel for the other side. The prayer is allowed. Let this matter be listed after 2 weeks.
May it please your lordship.
TBL.
Lordship, item 35 already listed 2 days and remains as leftover, lordship. So if your lordship permit, this matter may be taken at 2 PM, lordship.
What is the matter?
Lordship, condonation in the criminal revision, lordship. Already the matter has been settled between the parties, lordship. So other side also appeared, they have no objection, lordship, in the condonation application.
You have informed the other side also
Yes,
regarding
lordship,
your mention.
lordship. He will also come at
Okay.
good, lordship. Oh, bless.
Item number 1.
May I please, your lordship? Lordship, by this 483 application, lordship, annexure lordship, annexure 11, they order dated 23/11/2023, passed in PRC case number 574 of 2023, pending before the Honorable Court of CGM, Kokrajhar, lordship, taking cognizance, lordship, under section 417, 376 IPC, lordship. Lordship, kindly see, lordship, page 26, annexure 3 is the registered FIR, lordship. Page 26.
I think in this case, the records will be required because 376 will have to see her statement. 164 prior, 164 and her 161.
Lordship, though there is a allegation in the FIR that so she was raped, lordship. So for the charge sheet, annexure 10 is concerned, lordship, there is her statements was not supported, lordship. And lordship, both the parties had been in relation for about 6 months, 6 months, lordship. And as soon as it was discovered that the victim responded,
No,
lordship, was a
what is your submission? What does not support?
lordship, allegation of rape is not supported by the charge sheet.
That shall be looked into during trial, whether it supports or not.
Her
Obviously,
statement,
lordship, that's why proceeding started, lordship. Next date is 29 of this month, lordship. Lordship, till then, lordship, proceeding may kindly be state, lordship.
On what ground?
Lordship, both the parties, there's a consensual relation between the parties, lordship.
No, that is your submission.
Lordship, no, lordship, it is stated in the FIR, lordship.
Yes, Ms. Jahan.
in fact, whether it's consensual, whether she's not minor, I believe.
She is herself stating in the FIR, lordship.
No, I mean, her 164 statement, he has not annexed. Let us see his, her 164,
Lordship, that is
161.
required, lordship.
Because
but-
cognizance will be based on those statements.
Okay, we will issue notice.
Lordship will issue notice. And if your lordship wants, call for the scan copy of the case, record.
Heard Mr. A.K. Ahmed. A.K. Ahmed, learned counsel for the petitioner, also heard Ms. S. Jahan, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Mozahidul Islam, alias Mozahidul Islam. Which order you are in?
Order dated 22/7. I
Order
think.
dated 23/11.
Yes, lordship, 23/11/2023, lordship. Page 46.
23/11/2023, passed in PRC case number 574/2023, whereby the learned Chief Judicial Magistrate Kokrajhar took cognizance of offence under section 417/376 of the Indian Penal Code against the present petitioner. Issue notice to the respondents and call for the scan copy of the NCR, a scan copy of the PRC case number 574/2023, along with the scan copy of the case diary of Kokrajhar PS case number 269/2023. Since learned additional public prosecutor has declared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice by registered post with AD within 3 days from the date of this order.
Lordship, can be
Return-
within 7 days, Lordship, because
Within
Saturdays-
within 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed accordingly after 4 weeks.
much Lordship.
Wait.
Please, Your Lordship. Lordship, may I play after some time? Otherwise, in item number 14, the case diary is to be received by 2 o'clock. That has been told to me.
Lordship, I have been told by my knowledge friend, Lordship, that the case diary is lying in court number 22. So can it be fixed on at 2 PM, Lordship, so that we can take it?
For both the matters, item 14 and 15, both the matters. At 2.
All right.
Item number 16. Item number 16.
Pisot Mapi. We'll take it up later on.
Lordship.
Item 2.
My lord, may I be pleased to pass over the matter for some time as my senior is on leave in some other appointment.
Item 4.
Maybe please, Lordship. Kindly, Meta, maybe pass over for the day, Lordship, because my senior is not well. After 1 week.
Date may be fixed, my lord.
Heard Mr.
Yes, no.
S. Neo, learned counsel for the respondent,
Petition.
learned counsel for the petitioner, who prays for an adjournment today on the ground that his senior, who is the conducting counsel of this case, is not well. Learned also heard Mr.
Ego high.
A. Gohai, learned counsel for the respondent, who does not opposes the said prayer. The prayer is therefore allowed. Let this matter be listed after a week.
My lord, date may be fixed, my lord. May-
No,
Remain
date-
pending last,
After a week, registry will
okay. Oblige, my lord.
Item 5.
That's it. Intimata will shall continue.
yes, in earlier course, interim order shall continue.
Bas.
Who is, you are for the respondent?
The opponent, Mr. Chamaria may be there. And he is not present.
What is to be done now?
My lord, let it come in next week, on Tuesday.
Okay. None appears for the, you are for the petitioner.
Yes.
Heard Mr. O. P. Bhatti, learned counsel for the petitioner. None appears for the respondent. On request of learned counsel for the petitioner, let this matter be listed after.
No, Tuesday, my next.
You want a fixed date? Let it be fixed on, let this matter come up again on 13th of February.
Item 6.
Lordship, the petitioner in person probably not present.
petitioner in person.
Yes, Lordship. Hmm.
What is to be done?
Lordship, this matter may be passable for the day, Lordship, since he is
Okay.
absent.
The petitioner is person. Petitioner in person is absent. He is not found on call. Learned Miss S. H. Bora, learned additional public prosecutor is present. Let this matter be listed after a meeting.
Lordship.
Item number 8.
May I please, your Lordship, the item may be possible for a time being, the London Council is in another place.
Item 9.
Lordship, matter may be possible for the day. Can you fix next week?
You want adjournment today? You are for?
A. Hussain. I'm appearing on behalf of Mr. J. Hamid.
What is the ground for adjournment? On what ground? Your senior is not present.
I'm for respondent, Lordship. That's
You have-
number one.
You have any objection?
No, Lordship.
Heard Miss A. Hussain,
A. Hussain.
learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Mr. I. U. Chaudhary, who is appearing for the respondent number 1, does not opposes the prayer. Means the prayer is allowed. Let this matter be listed after me.
Okay.
Problem.
Item number 10. Item number 10.
None appears for the parties on call. Let this matter be listed after a meeting.
Item 11.
May I please, Your Honor? It's a legal aid matter, Your Honor. The conviction is to suffer RI for 10 years under section 376 2L and also another 1 year for under section 448 IPC. The victim's age is 20 years as per her statement.
For bail.
Yes, sir.
The appeal is not,
Criminal appeal. It's a criminal appeal for
appeal is,
admission.
this is for the first time you are
Yes, yes, sir.
heard Miss
And Hassan.
N. Hassan, learned legal aid counsel. Also heard Miss S. H. Bora, learned additional public prosecutor. This criminal appeal from our jail has been registered on receipt of a appeal petition by the appellant. Now, on filing of an appeal by the appellant, Shri Nayan Malik, under section 374 within bracket 2 of the Code of Criminal Procedure, 1973, impugning the judgment and order dated 3/6/2023 passed by learned Special Judge Jorhat in special case number 42/2022, whereby the present appellant has been convicted and sentenced, convicted under section 376 within bracket 2 within bracket 1 L of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 10,000 with default stipulation. The appellant has also been convicted under section 448 of the Indian Penal Code and has been sentenced to suffer rigorous imprisonment for 1 year and to pay a fine of rupees 1,000 with default stipulation. The appeal is admitted for hearing. Issue notice to the respondents and call for the LCR. Since the additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards the respondent number 2 is concerned, the appellant shall take steps for issuance of notice to respondent number 2 by registered post with ID within a week from the date of this order, returnable after 4 weeks.
Lordship, a copy of the appeal memo along with the IS will be furnished to us.
The appellant shall furnish a copy of appeal memo
Already financed.
One I can do.
along with the
All the detail,
annexures to the additional public prosecutor.
Lordship.
I have furnished the actual copy along with the
He has
intellectual.
not received.
এটা দিয়ে দিতে পারি। আমি জেরক্স করে জমা দিয়েছি। It will be considered after receipt of LCR.
In I also, this interlocutory application has been filed by the appellant, has been filed by the applicant under section 389 of the Code of Criminal Procedure, praying for suspension of the sentence imposed on the applicant by the order which has been impugned by the applicant by filing a connected appeal, that is criminal appeal number 14J/2023. Stop. Issue notice to the respondents. Since the additional public prosecutor has already appeared for respondent number 1, no formal notice needs to be issued to respondent number 1. As regards to respondent number 2 is concerned, the petitioner shall take steps for issuance of notice to respondent number 2 by registered post with ID within 7 days from the date of this order, returnable after 4 weeks. The interlocutory application shall be considered after receipt of the LCR, which has already been called for in connected criminal appeal.
Lordship. So in the meantime, we'll file objection. Lordship.
The state respondent may file objection in meanwhile.
Obliged.
Let this matter be listed after 4 weeks.
Next.
Item 13.
May I please, Your Lordship? Father, this is a quashing of the complaint, my lord. Apparently, my lord. LCR has come, my lord. Apparently, my lord, it's absolutely the commercial dispute, my lord. Both are the company between the complainant and the petitioner here.
And making submission for final disposal.
Yes, my lord, Lordship can final disposal. It's a very small matter, my lord. Lordship can go through the complaint and can decide. Because this is absolutely purely a commercial dispute where it appears that we used to take their services for recruitment of our employees, madam. So accordingly, they used to provide us, as per our requirement, the manpower, basically. So dispute arises in between regarding the payment of the services, madam. That is the only. Now, Lordship, can you see the complaint petition here is page 43.
Yes, Tim.
Has your lordship got it, my lord? It starts from page 43.
Yes.
Now, complainant is, my lord,
What is your prayer in this
quashing of the complaint, my lord.
question of the?
Because the no prima facie case has been made out under section 420.
Yes.
So this is a complaint filed by the one Neha Sharaf. She is the representing director of Growth Maximizers Private Limited. Those representing that company, my lord. And the accuser, my lord, the Ashima Housing Private Limited, that's the company. Then the Manish Mahendra Choksi, that's the director. Ramchandra Kashgur Kamath, that's another director. Sanjay Gupta, director. Shubhalal, director. All are resident of Delhi, my lord. Nidhi Kumar, director, resident of Gujarat. So these are all the directors who has been made accused along with the company, my lord. Now,
All the accused are the petitioner in this case.
yes, yes, all the directors along with the company. That Mrs. Neha Sharaf, I'm reading from 44, my lord. Mrs. Neha Sharaf is the complainant in the director of the private limited company carrying on business of the name and style of the Growth Maximizers Private Limited and having its registered office at the Sarab Building, first floor, 80 Road, Guwahati, so-and-so, who takes care of the affairs of her business and the manpower recruitment and hiring of the consultancy under the director of the supervision of the her husband, Sri Kapish Sharaf, and both of them fully aware and the facts and circumstances of the mention of the complaint. Number 2, the complainant is engaged in the business of providing hiring the all industries by the securing the candidates to their clients, which is spread throughout the length and breadth of the country. Though the complainant company is situated in Guwahati, the business of the complaint takes place in various cities throughout the length and breadth of the country. The accused number 1 is one of the company working under the brand name Your Space, and the accused number 2 to 6 are the directors of the accused of the company, each of whom are equally responsible for managing the affairs of the accused number company, being in the charge of the affairs of the company in their capacity as a director thereof, and each of them is jointly and severally liable for the respect of the offense committed by the
What
accused
is the
number.
business of the complainant?
Business of the company is the hiring, recruiting the services, the manpower, basically,
For?
for the various companies, madam. The complainant. They used to, as per the requirement of the various company, they used to recruit on behalf of our company, madam. So basically they are the outsourcing. We are outsourcing them to recruit the person on our behalf, madam. That is their basic, madam. The accused company requested the complainant company to start providing their services for hiring suitable candidate, and the complainant company informed the accused about the terms and condition of the service initially in 15/5/2020, as well as later on 10/2/2021, 14/2/2021, 16/11/21, 23/5/22, and 6/6/22. But the accused, due to do unexcused or other, always choose not to sign the service agreement, but choose to confirm the terms and condition upon mail. The complainant company started providing the headhunting service to the accused company on the agreed terms and condition, but the accused always used to violate the agreed terms and payment of
What
the
is this
withdrawing the
headhunting service?
My lord?
Headhunting service? What it
Headhunting, my lord, that is they're looking for the various people, my lord, suitable candidate for our company.
For
As
accused,
per, yes,
for the accused company.
accused company.
Okay.
So accused always used to violate the terms of the payment of the by withdrawing the payments of the complaint unnecessarily and pay the same after repeated persuasion on emails. 6, my lord. After providing few candidates to the accused company, the complainant company sourced 2 candidates, namely Sridhar Prabhu Anantaram and Nikita for the accused company as per their given requirement. The entire process of selection of the both these candidates as per the given requirement, motivating the candidate to explore the option of the working with the accused company, scheduling meeting, interview between the accused company and the said candidate was undertaken by the complainant company. But in respect of the Sridhar Prabhu Anantaram, one Mr. Binayak representing the accused company instructed the complainant not to coordinate with the Sridhar Prabhu Anantaram and he wanted to deal with him himself. It is pertinent to note that the candidature selected by the complainant was apt and both of them are working till today with the accused company. The complainant company raised invoices dated 17/5/22 rupees 3,24,500 in respect of the charges of hiring Sridhar Prabhu Anantaram and invoice dated 18/5/22 rupees 1,06,200 in respect of the charges of hiring Nikita, that is total 4,30,700. Upon the accused intimated the same to the accused by email dated 19/5/2022. That after availing the service of the complainant company in respect of the hiring the two candidates, the accused company now started to harass the complainant company, asking them to reduce the invoice amount to some excuse and other. The accused out of the blues demanded an adjustment of the service charges of hiring the Anish Dhatavkar, which is already paid up by the company after a long persuasion. It was also pointed out that neither of the employee resigned within 90 days, nor they were any code of conduct violation in part of thereof. The accused company is not entitled to any adjustment. The legal notice dated so-and-so has dispatched to the accused by email on 27/7/2022, which was received by them instantly and by registered post, which acknowledged with the dues to deliver to the accused alias so-and-so. It was again pointed out that the accused in the said legal notice that after having recruited Mr. Anish Davatkar through the security interview process, it was accused terminated Anish on the ground of lack of performance. The fault on the same might rest upon the interview panel and the accused company is not on the complainant company who have provided all their services by resourcing candidates as per the requirement of the accused candidate with the accused company and candidates are continuously the smooth conduct of the process of the recruitment. 10. The complainant was shocked and to the extreme because even after pointing out everything specifically in the legal notice dated 27/7/22, complainant received an undated anonymous reply with the accused company through their so-called legal department without any name of the signatory by email dated so-and-so, wherein the first time the accused company had made a feeble attempt to allege Mr. Anish failed to attend the minimum working hours and paid the false story, and they did not terminate within the initial 90 days on the ground of illness of his mother. As such, the accused wrongly and intentionally claim adjustment and overdue service charges towards the hiring of Nikita from the belatedly paid services charges towards the hiring of the Anish Davatkar as a matter of right in order to retain the payments due to the complainant and draw illegal gains out of them. Further, the accused brought a new story altogether as regard to the services charges towards the hiring of the Sridhar Prabhu Anantaram, which is again misleading more so when the complainant company acted totally under the instruction of the accused company in respect of the said hiring. The complainant specifically likes to point out that the accused, with the fraudulent intention through their representative called Binayak, initially tried to cook different stories for trying to not to pay the services charges related to the hiring of Sridhar, but thereafter on so-and-so, he agreed to pay the same. But now the reply dated nil, they have again came up with the story to try not to pay for hiring the Sridhar through, though they have availed input tax credit against the invoice issued by the complainant already on 2022. Similarly, as regards to the dispute related to the hiring charges of Anish portrayed by the accused, once they said that Anish was asked to resign on performance issue upon being pointed out that the performance issues is not attributed to the complainant. They were feebly trying to connect his resignation to code of conduct and humanitarian service extended beyond 90 days, which is a malified intention. Further, the entire manner in which the accused has handled the early show cause that from the very beginning the policy was to induce services provided like complainant to provide services on credit and then to harass them by withholding their payments to draw illegal gain out of the hiring providing the payments withheld. That only on 12/8/2020, complainant came to know that the accused is into the habit of playing dirty games with their vendors on the unfounded grounds, knowingly that the malified intention by intending service providers like the complainant to provide their services to credit basis and to reduce their legitimate dues by withholding their payments by way of extortion with the pre-plan designed to dishonestly convert their own use all payments which are supposed to be made by to the complainant in violation of the express agreement amongst them, touching the discharge of the aforesaid trust. It is also strange to see that the accused intentionally ignores the basic practice of the industry, which thereafter the complainant mentioned about the same in their legal notice. They have chosen to create the false story on those aspects of their reply intentionally to retain payments with them illegally. Which more surprisingly is even that after dispatch of the legal notice to all the directors of the company in charge of the affairs of the company, good sense did not prevail on none of them and acted responsible to stop the illegal retaining the payment by the accused company, but all of them collectively justified their legal act to collectively deceive the company under common intention. The complainant get to know only on 12/8/2022 that the accused has criminally intention at very beginning and the accused has made some false misrepresentation with the intention to defraud the complainant company. The criminal intention of the accused further came to the light of their illegal acts and the responsible legal notice sent by the complainant. Then till that the complainant is entitled to receive 4,30,700, which have been illegally retained by the accused from the complainant in the name of extortion. Therefore, the criminal intention of the activities of the accused has exposed in the complainant to serve the prejudice causing the huge losses to the financially. 15, this is very important, my lord. That the complainant resident of the Guwahati and all services were made by the complainant to the accused electronic and earlier payments were made by the accused to the complainant at Guwahati. This is important. The accused has committed an offense of the Guwahati SSD Act, Rias as the present so and so jurisdiction of Guwahati cognizance offensive as per law. So admittedly, the initially payments has been made to the complainant for hiring the services, my lord. Subsequently, disputes that arises between the company. We have objected some of the things regarding we have asked them to reduce the invoice prices which they have quoted. For in between, my lord, there are several communication as per admitted, my lord, they have issued notice to us. We have replied to us. So whatever may be that the reason, my lord, and whatever may be the allegation from complaint, my lord, the requirement of the fraudulent intention from the very initial reception and fraudulent intention from the company or from the petitioners, that is missing, my lord. It was a continuous business transaction, admittedly, they said. An earlier occasion we have paid, it's not that we have not paid in single farthing to the company. Their own admission is that it was paid. Later on, regarding recruitment payment of the 2%, my lord, the dispute has arisen subsequently, my lord. So we have also demanded some adjustment regarding some other candidate because he has left the job. That is a dispute, absolutely, my lord, the civil one, civil dispute, because of the commercial transaction between the parties. Where is my fraudulent intention from to deceive them, though they have made the language, my lordship knows it, just to create an offense, only just the mentioning the section will not do. That they have to come out with the evidence, with the material facts by which they can show that we have deceived them from the very beginning, at the inception, and that deception has to be a fraudulent one. Two things is required to take the cognizance of 420, my lord, under section 415. That deception has to be at the earliest, at the beginning, inception. Here, there is nothing. Rather, the admitted fact is that the transaction between both the parties was going on. They have received the earlier payments also with regard to only 2%, which has been hired on our behalf. They have raised the invoice. We have objected to the invoice. We have asked them to reduce the invoice amount. Then they started the dispute. Where is the fraudulent inducement? And we have to induce that company fraudulently, madam. To that effect, there is no material. Simply they are making it that we have done it fraudulently, we have not done it. There is a violation of the condition of the agreement. These are all said the civil dispute, my lord. Just to, they have put in a criminal color just to harass us. This is apparently absolutely case of, my lord, to make a civil dispute, to make it a criminal color, giving a criminal color. And to that effect, my lordship knows there are several judgments. I am relying on the cognizance has been taken in this case under 420, my lord. Now, I am relying on the first judgment, my lord. That is 2015 8 SCC 293, my lord. Paragraph 12, I will not go into the entire thing, my lord. Paragraph 12 is sufficient, my lord, to understand the concept of 415, my lord. Paragraph 12, my lord. May I read?
Yes.
From the decision cited by the appellant, the settled proposition of law is that the every breach of contract would not give rise to an offense of the cheating, and only in those cases breach of contract would amount to cheating where there is any deception played at the very inception. That has to be very clear. Here, there is no deception at the inception. Admittedly, payments has been made to them. Transaction was going on. If the intention to cheat has developed later on, the same cannot be amount to cheating. Even the later part, there may be some intention may be derived, but that will not create an offense of the cheating. In the other words, for the purpose of the constituting the offense of cheating, the complainant is required to show that the accused had fraudulent and dishonest intention at the time of making promise and representation, my lord. There is not even a single abatement to that effect. That at the beginning, we have misrepresented them fraudulently, and then we have taken this
In
up.
paragraph number 13 of the complaint petition.
Yes. Paragraph number 13, lordship, can we see? It is a complainant got to know on 12/8 the accused has criminal intention from the very beginning. That is only the abatement. To that effect, how? They have to make out a case, how this is. Because otherwise, everyone can say that we have been defrauded, we cheated him. That will not do.
They have to explain.
That has to, there is some explanation there. I'll place the judgment also. So that part has to be explained. How the cheating, how the fraudulent intention or misrepresentation has been played. Only simply the mentioning the section, the requirement of the section will not do. I'll place the judgment on that. Even in a case where the allegations are made in regard to the failure on the part of the accused to keep his promise, the absence of culpable intention at the time of making the initial promise being absent, no offense of the under section 420 penal code. So the third limb of the case is that there has to be the intention on the part of the accused to cheat. These are the requirements to constitute an offense under section 415, my lord. These are the requirements. Here, no. Next judgment, that is a recent judgment, my lord. this judgment from our High Court, our High Court has refused to entertain the petition, my lord. Ultimately, the Supreme Court has allowed, relying on the other previous judgment from 7.2, the VESA holding. Now, point 7.3, my lord.
Relevant paragraph is
7.3. 7.2 is the other judgment which has been already relied, that the VESA holding. The next one is 7.3, Hira Lal Hari Lal Bhagwati. The 40, it is settled law by a catena of decision that for establishing the offense of cheating, the complainant is required to show that the accused has fraudulent and dishonest intention at the time of making the promise of the representation. This is very important. He has to show and avert a specific act from which the court can derive is, yes, this was a fraudulent representation and the fraudulent act on behalf of the accused at the inception. Some act has to be attributed, madam. Simply just showing it that he has caused a fraudulent intention, that will not do. From the making failure to keep promise subsequently of the culpable intention, right from at the beginning, at the time when the promise was made, cannot be presumed. So that presumption is not also available. Subsequent failure not to follow, there is no presumption that we had the intention from the very beginning to cheat. Even somebody fails to make the promise, entertain the promise, that the presumption is not also available, my lord. It is seen that the record, this is not important, my lord. Now, 7.4, my lord, U.V.Y. Jose. It is observed that held at the court that one of the ingredients of cheating is the existence of the fraudulent and dishonest intention of making initial promise or existence of thereof. So here, that initial fraudulent deception, there is nothing. Simply they had quoted the section, madam. Dishonest intention making the initial promise existence thereof from the very beginning of the formation of the contract. It is further observed at the hill that one thing is to say that the case has been made out for the trial and such criminal proceeding should not be quashed. But it is another thing to say that the person should undergo a criminal trial despite of the fact that no case has been made out at all. Now 7.6, my lord. Joseph, it is observed that the held by this court that when the dispute between the parties constitutes wrong, the court would not permit a person to be harassed through no case for taking cognizance of the offense has been made out. Next, 7.7. It is observed that the held by this court that the court must ensure that the criminal prosecution is not used as an instrument of harassment and for seeking private vendetta or with an ulterior motive to pressurize the accused. What is happening in my case, my lord? Now, 8.1, my lord. It is observed here and above, the charge sheet has been filed against the appellant for the offense of the 420 read with section 120B. However, it is required to be noted there is no specific allegation and avertment in the FIR or even in the charge sheet that the fraudulent or dishonest intention of the accused was from the very beginning of the transaction. Now, last line, my lord, last 3 lines, lordship, can you see on 8.1, last 3 lines?
yes.
In any case, there are no specific allegation and avertment in the complaint that the accused had the fraudulent and dishonest intention at the time of entering into contract. Therefore, applying the law laid down by this court in the aforesaid decision, it cannot be said that even a prima facie case for the offense under section 420 has been made out. So they have to specifically avert how we have cheated them. What was our false representation? What was our fraudulent at the inception? That has to be specifically averted in the complaint. Here is that part is absolutely missing. Rather, here they have admitted that initially they used to receive all the payments. Subsequently, in the midway.
At what stage this complaint is pending now?
Now it is for now we have come after the receipt of the summons, we have come before this court.
The It is in-
Summon has been issued, madam. Under
whether
420.
it has been stayed,
Stayed.
at the stage of appearance only.
Yes.
Okay.
Now, 8.2, it is also required to be noted that the main allegations can be said to be against the company. The company has not been made a party. Here, company has been made the party, madam. The allegations are restricted to the managing director and the director of the company respectively. There are no specific allegation against the managing director or even the director. There is no allegation to constitute a vicarious liability. Here also, Lordship, there are several director Lordship has seen. No specific allegation against each of them, how they have fraudulently induced, if that be so, to the complainant. Simply, the allegation is that they have not acted properly when their prayer has been made, they remain silent. That is specific allegation against the directors. They are looking after day-to-day management, that's a different matter. But regarding this dispute of offense of alleged 420, they said they are inactive at the time when the prayer was made. They are silent regarding the release of the payment. That is their offense. That can't be an offense of 420, madam. In this case, madam, I am relying on the 23, paragraph 23 onwards, but 23, 24, 25, 26, madam. 23, madam. Where also similar, madam. Now, 23, except the above allegation, there is no further allegation in the complaint. It was not even a case on behalf of the complainant that this, at a time when the compound wall of demolition trees were cut, the accused number 2, 5, 7, 8 were present. Except the bold statement that the accused number 2 to 5 and 7 to 8 has conspired with the common intention to lay the pipeline within the scheduled properties belonging to the complainant without any lawful authority, rights whatsoever, and the furtherance of they have committed the trespass into the scheduled properties of the complainant, demolished the compound wall. There are no other allegation that the date time were present. Accused number 2 to 5, 7 to 8 are stationed at the Hyderabad. There are no further allegation that the compound so and so, so and so, so and so. Last 3 line, madam. Therefore, as such, in absence of any specific allegation and a specific role attributed to them, the learned magistrate was not justified in issuing process against the accused number so and so, so and so, under so and so, so and so, so and so. So here also, there is no specific allegation against the director. And there is no vicarious liability is available in these cases, madam. Similarly, paragraph 24, in case of the Sunil Bharti Mittal, the observed by this code, the paragraph 24, no doubt the corporate entity is an artificial person which acts through its officers, director, managing director, chairman, etc. In such a company commits an offense of involving manslaughter would normally be the intent and action of the individual who act on behalf of the company. It would be more so when the criminal act is that is of a conspiracy. However, at the same time, it is the cardinal principle of criminal jurisprudence. There is no vicarious liability unless the statute specifically provided. So IPC there is missing, madam. Thus, any individual who has perpetrated the commission of the offense on the behalf of the company can be made an accused along with the company if there is a sufficient evidence in his active role coupled with the criminal intent. Second, intuition in which he can be implicated in those cases where the statutory regime itself attract the doctrine of vicarious liability by specifically incorporating such provision. Now, paragraph 26, my lord. As observed by this court in the case of the Pepsi food, so and so, even thereafter, the catena of decision of the summoning the accuser in a criminal case is a serious matter. the criminal law cannot set into motion as a matter of course. The paragraph so and so, paragraph 28, summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complainant has to bring only two witnesses to support his allegation in the complaint to have the criminal law sent to me. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. He has to examine the nature of the allegation made in the complaint and the evidence, both the oral and the documentary, in support thereof, and would be sufficient to complain to succeed bringing the charge home to the accused. So basically, this is my love. Now I am relying on the next judgment, my love. This judgment will cover everything, my love. Take care of that person, no? They are cheated in a- My lord, the inner page of this judgment, page 15, the second paragraph, my lord. The observation made by Honorable Supreme Court in India in Neelu Chopra versus Bharti.
Page,
Inner page 15, my lord.
yes. Yes,
The second paragraph, my lord. The observation made by Honorable Supreme Court. This is by your lordship. The observation made by the Honorable Supreme Court in India in Neelu Chopra versus Bharti, which is relied by the learned senior counsel for the petitioner and quoted below. In order to lodge a proper complaint, mere mention of this section and the language of those section is not the be the all and end of all the matter. That is required to be brought to the notice to the court is the particulars of offense committed by each and every accused and the role played by the each and every accused in committing the offense. This is the requirement. Only just quoting the section, that will not do much. They have to specifically mention how they have been defrauded, how the fraudulent act was committed, how deception has been made at the initiation manner. There is no allegation that the deception has been made, just an allegation, but there is no fact to the effect, man. Some facts has to be brought in, man, to supplement their allegation, man, to make a prima facie case of 420. Some facts. Only just replica of the section, putting the replica of the section, that will not do, man. That is the Supreme Court says. When we see the complaint is sadly vague and does not show as to which accused has committed what offense and what is the exact role played by these appellants in the commission of the offense. There could be said something against the Rajesh as the allegations are made against him more specifically, but he is no more and has already expired. Under such circumstances, it would be abuse of the process of law to the prosecution to continue against the aged parents of Rajesh as so and so, so and so, so and so. Vague and general complaint, which is silent about the precise act of the appellant. That precise act has to be there. Last one. So this lordship judgment has already, my lord, dealt with the all the provisions of the 420, how it has been made out, when this requirement, what is the requirement, what is the abatement necessary to make a case. Simply putting the words of the section will not do.
In this case, cognizance was taken under
420.
420 only.
Yes. So, my lord, this is a fit case, where no case has been made up. Absolutely commercial dispute. Just to make an harassment, they have filed this matter. And the learned magistrate also, without going to the complaint, without applying his mind, my lord, has summoned all the accused, though there is no specific allegation against any of them, my lord. How they have fraudulently represented the commercial dispute can arise at any time, my lord, but it ipso facto does not create an offense under 420, my lord. There has to be fraudulent deception, inducement, these two parts. That deception, they have to make out a fact to that effect, how they have been deceived at the inception. To that effect, the complainant is absolutely silent. Rather, the paragraph, the last paragraph, rather they have admitted the paragraph 15, page 49. This is very important. That's why the complainant is resident of Guwahati and all the services were made by the complainant to the accused electronically, and all earlier payments was made by the accused to the complainant at Guwahati. So there is a commercial transaction was going on. It's not that from very beginning we have stopped the payment. Not a single farthing was paid to the company. It was made. Payment was made. They have received. They are giving the service. It was continuing. Subsequently, at the middle of the point, as they have raised some bills, we have objected to that. We have stopped the payment because of we wanted some adjustment. That can't be a fraudulent deception, my lord. That's all.
Lordship, a lot has been said about the fraudulent intention from the very beginning. So I would request your Lordship to peruse page 46. Paragraph 6 of the complaint, Lordship. If I may please read, that after providing a few candidates to the accused company, the complainant company secured two candidates, namely Sridhar Prabhu Anantaraman and Nitika, for the accused company as per their given requirement. The entire process of selecting both the said candidates as per the given requirement, motivating the candidate to explore the option of working with the accused company, scheduling meeting interview between the accused company and the said candidates was undertaken by the complainant company. But in respect of Sridhar Prabhu Anantaraman, one Mr. Vinayak, representing the accused company, instructed the complainant not to coordinate with Sridhar Prabhu Anantaraman as he wanted to deal with him himself. It is pertinent to note that the candidature selected by the complainant was so apt that both of them are working till today with the accused company. So, Your Honor, when I point out this paragraph in respect of submission regarding the fraudulent intention from the very beginning, when the hiring of this candidate process started, an initial request was made by the accused that you people don't coordinate with the candidate. We will be talking to him so that we can ensure that he's on board. Subsequently, they withhold the payments, and when notice is given to them, they take a plea as page 40, Lordship. 41, sorry, which is the reply to the legal notice sent to them. If I may please read, Lordship, that your client had admitted
Where
that.
are you reading at page 40?
41, Lordship. This below the middle part. That your client had admitted that another candidate, Sridhar Prabhu.
Where? Page 41?
41, after the mid part, Lordship, that your client had admitted that another candidate.
Which line? What is this? This is a notice.
This is reply to our legal notice, Lordship. Before filing of the complaint, we had sent a legal notice to the accused and the directors. And they replied to the same by sending this reply, in which they say that Mr. Sridhar Prabhu Anantharaman had outrightly denied the opportunity to work with us after your client spoke to him, as he felt that the job description informed by your client did not correspond to his profile or requirement. However, when our CRO spoke to Mr. Sridhar directly, it was then that he showed interest in applying for the opportunity with us. This clearly indicates that our client does not understand the job description appropriately and without understanding the requirements have been providing candidates, as a result of which we made a wrong hiring of Mr. Anish, some earlier candidate, Lordship. Surprisingly, when we informed about the wrong hiring of Anish, your client, instead of introspecting and regretting the mistake, tried to shift the burden on us. So, Lordship, in this case, what has happened is at the time of sourcing the candidate, they say that no, we will take charge and we will talk to him. And when payments are sought and they are retaining the candidate, they say that no, you were not competent to talk to him. So that was the reason why we had talked. So now we will not pay. So is this not a fraudulent intention from the very beginning, Lordship? They have planned it very earlier that no, we will take this and this plea so that we can withhold the payments. Now, as regards the candidate Anish, he was sourced earlier. Payments in respect of his hiring was paid to us. Now, they say that no, we had terminated the services of Anish after 90 days. It was agreed between us that if that candidate leaves himself within 90 days, you will not be supposed to pay. Now they say, no, we did not terminate him during 90 days because his mother was ill. But since after that he left, we will not pay. So these type of pleas, Lordship, to withhold the payments. If it is not fraudulent intention, what is this? This is absolutely cheating.
No,
And every basic government is there in the petition itself. They talk about vicarious liability, Lordship. They say that no, the person who specifically commits the offense, only he will be liable and not the directors who will be liable. So, Lordship, this all communication was handled by one Mr. Vinayak on behalf of the accused company. That Mr. Vinayak, whatever his acts were, in the reply to the legal notice, all the directors have endorsed his acts. So they all have become a party to the offense, which shows that all of them were involved from the very beginning. And all the basic governments are there in the complaint petition, Lordship. They would take services. It is not that they have to specifically take some goods or money to deceive someone by way of cheating. If they take away the services by way of deceiving someone, that will also resort to cheating, Lordship. And your Lordship is also well aware that a transaction may have a civil color as well as criminal color, and both may be applicable also. There is no such law that if say, civil remedy is there, there will be no criminal remedy.
No, but you have to show that ingredients of 420 are also present.
Yes, Lordship, that is what I have shown just in paragraph 6. They say that don't talk to him.
Merely by saying so, whether the ingredients are 420 are satisfied.
Lordship.
Because the hiring of Sridhar and Anish,
Lordship,
was on your request. They used to hire.
I used to hire. I used to
You
provide
used to hire,
candidates.
Yes.
On their request, on their requirements.
And the the petitioner had to make payment.
Petitioner had to make payments, which he did not.
Now they are not making payment because they have raised certain objections.
At a subsequent stage, after I started asking for money, not before that, Lordship. And Lordship, in the complaint petition, that a warrant of arrest was issued against them, that fact has been concealed, which will be apparent from the LCR.
No, what has been concealed?
Warrant of arrest was issued against them, and that statement has not been given in the petition before your Lordship.
For non-appearance.
Lordship.
Okay. That is a different aspect.
That is a different aspect, but I was just pointing it out, Lordship.
No, but where is the averment in your petition, in your complaint petition? Apart from paragraph 13, that they had nullified intention to defraud you from the very beginning.
Paragraph 12 and 13, Lordship. That only on 12/8/2022, when they gave a very clever reply to the legal notice, the complainant came to know that the accused is into the habit of playing dirty games with their vendors on unfounded grounds, knowingly with malified intention, by inducing the service providers like the complainant to provide their services on credit basis and to reduce their
But
legitimate use.
you had continuous business transaction with the accused.
Lordship, they have to make some payments in the initial beginning of the series of transactions, because only then the subsequent transactions they challenge that no, that was wrong. You adjust this. If they do not even make a single payment, they will not get that scope. To create that scope, that has to be done by them, Lordship. Now, Anish's payment was done. But now they say that no, subsequent hiring candidates, you adjust with Anish because he left, because he was terminated later on. If they do not make these earlier payments,
Now, this outstanding that the amount of 4,30,700,
that is regarding Sridhar and Nikita.
Sridhar and Nikita or Anish?
Sridhar and Nikita. Now they say that you adjust Anish dues which was paid earlier. So if they do not pay, they cannot ask for adjustment. So that is a part of the game plan.
Yes, proceed.
So Lordship, as I have already submitted that since the criminal intentions from the very beginning is very apparent from the facts which have been appropriately set out in the complaint petition.
In paragraph number?
12 and 13, Lordship. Now they will withhold payments and they will say that no, that earlier transaction you adjust. Otherwise, we are not going to pay. So this is their game plan. With a pre-plan designed to dishonestly convert to their own use all the payments which are supposed to be made to the complainant in violation of the agreement amongst them, touching the discharge of the aforesaid trust. It is also strange to see that the accused intentionally ignores the basic practices of the industry, even after the complainant mentioned about the same in their legal notice, and they have chosen to create a false story on those aspects in their reply intentionally to retain payments with them illegally. What is more surprising that is even after the dispatch of the legal notice to all the directors of the company in charge of the affairs of the company, good sense did not prevail and none of them acted responsibly to stop the illegal retaining of payments by the accused company. And all of them collectively justified their illegal act to collectively deceive the complainant company under common intention. So Lordship, that vicarious liability submission, because all of them have been endorsing the acts of their Mr. Vinayak, who was the committing the offenses. Once all of them are looking after the day-to-day affairs and they are endorsing all the acts, they all of them become involved in the offense, Lordship. So the cognizance was rightly taken against all of them. And before filing of complaint, Lordship, innumerable number of chances were given to them that you settle, we don't like to go into legal process, you settle. But no, they don't want to. They are in a practice of withholding payments on deception. Innumerable number, there are email exchanges. Initially, they were ready to pay for Sridhar. Now, after legal notice, they have a contrary stand for Sridhar. No, we had talked with Sridhar, we will not pay.
No, what are the ingredients of 420?
Lordship, whoever cheats and thereby dishonestly induces the person deceived to deliver any property to any person or to make, alter or destroy the whole or any part of a valuable security or anything which is signed or sealed and which is capable of being converted into a valuable security. So in this case, Lordship, they have dishonestly induced the complainant to deliver the services of manpower recruitment on a promise of deferred payment. So the first limb stands satisfied, Lordship. Whoever dishonestly induces the person deceived to deliver.
No, you want to say that at the time of engagement of Sridhar and Anish, they had intention not to pay.
Yes, Lordship. Yes, Lordship, because they had told me that you don't talk with him, I will talk. And now they take a plea that I had talked, I will not pay. So it was there from the very beginning of Sridhar process. That is my contention, Lordship.
Anything else?
That's it, Lordship.
Any reply?
Yes, First of all, my lord, admittedly, my lord, they have said this is a part payment is pending, admittedly. This is a part payment and this is a payment only regard to the Sridhar and Nikita. Regarding dispute, prior there is any dispute, nothing has been in the complaint, my lord. Whatever my learned friend is saying now, their habit of, these are not the part of the complaint, there is no, to that fact, there is no factual avertment to that effect. What I am saying, my lord, there has to be a factual avertment in the complaints, where from court can assume that there is a fraudulent intention on the part of the accused. Some facts has to be brought in. Only just mere mentioning the sections and the ingredients of the section, that will not do. And then you cannot develop your story in the later stage. You have to confine in the complaint petition. In the complaint petition, there's absolutely they're silent how we have cheated them. Simply because somebody, and very surprisingly, I'll show you one thing. My learned friend is harping on one person that Binayak has committed the offense. Ask him not to talk to the Sridhar. Now, if the Binayak has committed the offense, where is the accused Binayak, my lord? In the complaint, lordship, kindly see. Page 43. Who is this Binayak, my lord? He says that the Binayak has committed the offense on behalf of the company, and the Binayak is not an accused, my lord. Kindly 43. So, for the act of Binayak, who believes that he has represented the company, who has committed the offense as per him, he is not an accused, lordship, kindly see 43. Who are the accused? Not Binayak, man. Who is that Binayak, man?
They have stated that Vinayak representing the accused company.
Yes, but Binayak is not the accused here. The person who has, for them, that he has misrepresented them, he had the intention, to fraudulent intention, to deceive. And this is a subsequent, in the midway, this has developed. What the Supreme Court says, the
No,
subsequent failure.
There is no such averment that Vinayak has instructed to.
No.
For the purpose of deceiving.
No.
The only averment is that he asks that you don't speak to, I will deal with.
Yes.
That person Sridhar myself. Only that much.
And that much, even then, let us see that even Binayak representing us, he goes and say, you don't talk to him. We'll deal with him. Does it create an offense of 420, my lord? Because subsequently we may say that yes, Binayak, though you have placed this man, but we have requited ourselves, we have dealt with him, we have decided. Does it create a 420? It's a dispute of commercial dispute. You may say, yeah, no. Binayak was provided by us. Later on, you have recruited, you have made the payment, you have absorbed him. But where is the fraudulent intention, my lord? By whom? By the company. That has to be averted. Just saying it, now that we had the intention, that's why we have stopped them. The moment we have stopped them not to talk, you could have withheld that. Then no, we'll do it. We'll provide. We'll talk and we'll provide the service. You have allowed us to continue. Absorb the candidate. You have not objected at the time. If it is Binayak is your candidate, your person, provided to us, and we have requested you that we'll talk directly to Binayak, we'll deal with Binayak. Does it offense of 420? Where is the deception that we had the intention? That avertment is also not missing. That the Binayak, we have specifically stopped it. And
for the purpose of deceiving.
For the purpose of deceiving. Then later on will not make the payment regarding the Binayak. That is also not, and the Binayak is not an accused, my lord. Now, how can they say that the Binayak on behalf of the moment Binayak is not made an accused, their whole argument falls. They said that the Binayak has committed the offense of deception. representing the comments. It is the Binayak. If the Binayak is not an accused, my lord, then how can they say it? That the Binayak has committed the offense. The roots goes, my lord. The director may not know also. Nobody knows what the Binayak said, whether the Binayak exists or not today. Because the moment you have not made him an accused, his existence goes. And they said that he committed the fraud. He has deceived the company not to talk. He is the first point. So he is not the accused. How the rest of it can be? When the roots is not there, how then the others are vicariously liable for his action, my lord? That's all, my lord.
So to wipe out that possibility of Vinayak not being instructed by the directors of the company, particularly that legal notice was issued to the directors of the company, and they have endorsed the acts of Vinayak, which shows that all of them are involved. That is my humble submission.
Okay, we understand, but you should have made the Vinayak as an accused, because on the Vinayak has acted as your argument fraudulently on behalf of the company. If the Vinayak is not an accused, how the rest of the person can be an accused, my lord? That's all, my lord. That cannot be it's absolutely, my lord, the civil dispute. There is coloring it. The Bhajanlal aptly applied in this case, my lord. That is why the lordship in the paragraph, the Neelu Chopra's case is absolutely here. Fit in, my lord.
Mr. A.M. Bora, learned senior counsel for the petitioner, assisted by Mr.
B.L.
V.H. Chaudhary, learned counsel for the petitioner. Also heard Mr. S.S. Gupta.
D. Saraf.
B. Saraf.
D. Saraf, Lordship.
Heard Mr. D. Saraf, learned counsel for the respondent number 1. The hearing concluded, judgment reserved.
Item number 8.
Lordship, hearing this case, Lordship, yesterday, my lord, I had a talk. My lord, yesterday I had a talk with the client, my lord. He has instructed me not to proceed with the case. My lord, he'll engage some other advocate in this case. So, my lord, I need 3 weeks time because my client is from Dimapur, my lord. So I had to return the briefs, my lord. Because in the meantime, why I'm saying so, my lord? Because during pendency of this case, my lord, there was a divorce application by a separate set of counsel, my lord. Thereafter, they also filed a Sridhan case, my lord. Therein a different counsel appeared and they compromised the case and the matter was over there. This is what I have got the instruction, my lord.
Now there is no dispute.
No, my lord. As far as this party said that, he said that that counsel will argue this case also, my lord. So for that, my lord, I need 3 weeks time, my lord.
Granting you.
May it please your
You
lordship.
have-
Lordship, I am for the respond number 2, my lord. Even though there is no stay, my lord, they have not paid our maintenance, lordship.
You instruct your client to pay the maintenance.
That so yesterday also I have said, my lord.
From 2018
This
itself, we are
revision
not
is,
paying.
this revision petition is
Against a ex parte judgment, my lord.
There was no
directing-
stay as regard to the maintenance.
Directing
lordship.
to pay maintenance of 4,000 together with an amount of rupees 20,000 as compensation. That 20,000 compensation, my lord, was stayed by this honorable court, my lord.
but
Because-
that regular maintenance has to be paid.
My lord, from the records which I saw today, my lord, I can see that till 21, there is a signature of the complainant. Thereafter, my lord, I don't have instruction. That is why, my lord, I said so, my lord.
It is I have not paid till date, lordship, as per my instruction, lordship. Again, my lord, as per the divorce, my lord, we have filed a petition for transfer of the divorce to Jorhat, my lord, and this honorable court stayed the proceeding of Dimapur and now is pending, my lord. Therefore, no question of any divorce, my lord, in Dimapur, lordship.
No, my lord, I only said that
My lord, transfer petition 39 of
in
22
the
and this
we
honorable
filed, my
court.
lord.
His
I'm
plea
not the
is
counsel.
different. His plea is that the petitioner may change his counsel.
Yes,
okay, lordship.
Therefore,
Yes, lordship. Yes,
that is
so-
the main plea.
Right.
So we are allowing his
Yes, lordship. Yes.
heard Mr. A. Tiwari, learned counsel for the petitioner, who prays for an adjournment on the ground that the petitioner is likely to change the counsel representing him in this case. And therefore he prays for 3 weeks' time. The also heard Mr.
H. Rahman Lordship.
No, if the regular maintenance is not
Not paid
paid,
Lordship, yes, Lordship. They are
then you
not
can
paying.
go for execution in the,
Yes, that's,
that
that's
option is open.
yes,
for you.
Lordship, that's true.
So no orders are required from this court. Also heard Mr. What is your name?
H. Rahman Lordship.
A.H. Rahman.
H.
H. Rahman.
Yes, please.
Who does not opposes the prayer for the adjournment, considering the ground mentioned by the learned counsel for the petitioner.
My lord,
And-
may I pay for a date, Lordship?
Hence the prayer is allowed. Let this case be listed after 3 weeks of the date. 29 February.
Deeply obliged, Your Lordship.
Item number 2.
But here we challenge the order of the Domestic Violence Act, my lord, 36, 2014. My lord, in the meantime, my lord, the divorce was granted by this court, my lord. I would use a bench order there is there. The lordship may see the order of the imperial order 36, 2014 at page 16, my lord. And this order, the lordship may see the page 23, my lord. On limited ground, it has been dismissed on the point of limitation, which was not the point for consideration before the court, my lord. The appeal was admitted and it was heard. Lordship may see page 23, my lord. Operative portion, my lord. In our last, my lord, last 2 lines. In our case, apparently there is delay, but no petition under Section 5 of Limitation Act was filed. Therefore, the appeal is barred by limitation. My question is, this was not that issue, my lord. The court himself has dismissed on the ground of limitation, which was not the subject matter, because otherwise appeal would not have admitted, my lord. If there is barred by limitation, the appeal would not have been admitted, my lord. But the last plea saying that it's barred by limitation, my lord, I don't find any reason, my lord, to pass that order on limitation, man.
No, but if it is barred by limitation.
Yes, but
and unless the delay is condoned,
no,
that
that's
it
correct, my lord.
remains barred by limitation.
Yes, for that reason also, my lord, I have shown in the ground number 6, my lord, lordship may say ground number page 6, ground number 2, that otherwise also it is not barred by limitation, my lord. I've given the date, my lord. And the learned court below does not give any finding that how it is barred by limitation, my lord.
Okay, you have justified that
Yes,
it
my
is
lord.
not barred by.
Yes, yes. Page number 6, my lord, ground number 2. I've given the date 26, 2014, date of judgment and order. Lordship may see
Just a minute. Page number 6.
page number 6, point number 2, ground.
No, this revision is against that order of,
Yes, against the order dated, my lord, 36, 2014, passed by additional decision session judge, my lord, ho jai.
in criminal appeal number
My criminal appeal number, my lord,
24.
24 N of 24. That is page 16, my lord.
Okay.
And lordship may see that we applied for certified copy at page 27.
Now, that appeal was preferred against which order?
This order, my lord. Judgment order 26/2/14, my lord, by the learned court of judicial magistrate ho jai.
Where is that order?
That order is page 27, my lord. Lordship may see 28/2/2014. I applied for certified copy and I received on 5/3/2014. There is also 6 days delay, my lord. So I,
This original The order was passed under section 12 of the
Yes. Section 12.
Prevention of Domestic Violence. Okay. What was direction? What was the
Ultimate direction is that the lordship may come to page, my lord, 43. It order that is. OP of the petitioner directed to pay 6,000 house rent payable every month with effect from today within 7th day of under section 19. Then lastly, that OP is directed to pay 1 lakh maintenance in lump sum to his daughter. And lastly,
who was the petitioner? The-
petitioner was the husband, my lord.
No, before the original court.
Original court, my lord. Nandita, the wife, my
Wife was
The
the
wife.
petitioner.
wife filed a domestic violence act.
And the direction was to pay
Yes.
to 6,000 to the wife or to the daughter?
To the 6,000 house rent payable every month with effect from today within 7 day of the next season. That is my lord, house rent 6,000, my lord. And OP party returned immediately following Sridhan.
The
Then-
lump sum was paid to the daughter.
Yes, lump sum 1 lakh rupees as a maintenance to his daughter. Now, in between, my lord, the divorce, my lord, I've given that order, my lord. Lordship may see that order. 2318, this. Now, this maintenance has been fixed by the court, my lord. Lordship may see page, internal page number 5, serial number 7, my lord. As regards alimony, a joint application being IR number so and so has been filed by the respondent and the appellant, stating therein that farmer shall pay rupees 12,000 per month on or to the latter, and the amount shall be deposited every month in her bank account. The application has been filed in terms of settlement arrived at between them. We accordingly direct the respondent to deposit 12,000 every month in the bank account of the appellant. The application is allowed.
Okay.
So the matter more or less come to end, matter. He is depositing every month, and in fact, matter, he is paying to his daughter also, matter, because that till
But whether this amount of 1 lakh has been waived, whether you have paid.
that is matter is merged with that, I would say that matter because of
There
this
is
order.
no order to that effect.
My lord, because the lordship may see that this will clarify, my lord, that as regards permanent alimony joint application, they both the petitioner and the respondent file joint application, my lord.
As regards permanent.
Yes. So that is the final, my lord. Because otherwise, my lord, I would not have pressed this petition, my lord, because they have jointly agreed to get 12,000 rupees per month, my lord.
Lordship, I have not obtained such type of instruction, Lordship. Lordship, kindly
Because
allow one
if
stand.
it is jointly, then the
Yes,
other side would also agree to this.
Yes, that is the thing.
Lordship, kindly allow one of them, Lordship.
To see, let them seek instruction.
And in fact, my lord, till recently also I'm paying every time my daughter to my.
No, now your submission is that this 1 lakh maintenance in lump sum that was directed to be paid by the present petitioner to his daughter has been merged
Yes,
with
ma'am.
the
Yes,
order of permanent alimony,
right, ma'am.
which was passed
On
by this
22
court on
22/3/18, ma'am.
22/3/18. So let her seek instructions,
I leave it to your lordship.
because if it is a joint petition,
Yes, ma'am.
they will be in agreement with that.
Yes,
And
they filed affidavit, my lord, to the court.
but
both of them.
not specifically mentioning that we are waiving this 1 lakh.
But she also signed the affidavit and husband also signed the affidavit. Joint affidavit.
No, that was with regard to permanent alimony only.
Of course, my lord, the divorce, my lord, lordship will see that matter by end of the matter, my lord, so far any other thing is also confirmed, my lord. That's the finality, my lord.
Heard, Mr. Let her seek instruction. heard Mr. J. Roy, learned counsel. Also, Miss, what is your name?
P. Udhigari.
P. Adhikari, learned counsel for the respondent. Learned counsel for the petitioner has submitted that during the pendency of this criminal revision, the parties have this court in a division bench of this court in Matt Appeal number 38/2018 by order dated 22/3/2018 have allowed divorce between the parties and have also directed on the basis of a joint application filed by the parties that the present petitioner will deposit rupees 12,000 per month as what?
As permanent aluminum.
As permanent alimony to the respondent. Learned counsel for the petitioner has submitted that the order of Learned JMFC Hojai passed on 2/4/2014, whereby the petitioner was directed to pay rupees 1 lakh as maintenance in lump sum to his daughter, as well as rupees 6,000 as house rent per month to the respondent has been merged in the order passed by the division bench of this court on 22/3/2018. As the said order was passed on the basis of a joint application in terms of mutual settlement arrived between the parties. On this, Miss, what is your name?
P. Udhigari.
P. Adhikari, learned counsel for the petitioner, learned counsel for the respondent submitted that she does not have any instruction in this regard and seeks some time to take necessary instructions in this regard. The prayer is allowed. Let this matter be listed after 2 weeks.
Date be on 26th, my lord.
Let this matter be listed again on 26th of February, on which date learned counsel for, and on the said date, learned counsel for the respondent would inform this court as regards the submissions made by learned counsel for the petitioner regarding merging of the order dated 22/2014 passed by JMFC Hojai regarding waiving of the maintenance allowance of maintenance allowance in lump sum which was directed to be paid by order dated 22/2014 by JMFC Hojai in view of passing of order on 22/3/2018 in MAT appeal number 38/2017.
And lordship, they also need instruction, my lord, because I sometimes can always, the chart I've given, my lord, I used to pay to my daughter. That I've given that extra chart, my lord. Yes, so whenever she requires, she used to call me, then I used to pay, my lord. So lordship will record that also, that
This is,
This is daughter, my lord.
but this is not in terms of any order.
That's it, out of love and affection, my lord, I used to give.
Learned counsel for the petitioner has also submitted that the petitioner used to regularly pay different amount to his daughter as and when it is required. And he has submitted a chart showing the payment by the petitioner to his daughter on various dates. Let a copy of this chart be furnished to learned counsel for the petition, learned counsel for the respondent also, so that she can verify it from the respondent.
Right.
Let the matter be listed again on 26 February.
Right. Obliged.
I'm taking a short break.
Item number 17.
May I please, I'm sorry to state that I cannot able to take the stairs, my lord. So today we will take it. It's because the respondent also frequently changed the address. He was not in this address, my lord.
Heard Mr.
C.S. Raymond.
C.S.
Rai.
Rai, learned counsel for the petitioner, who prays for some more time for taking steps for issuance of notice on the respondents. The prayer is allowed. The petitioner shall take steps for issuance of notice on the respondents within 7 days from the date of this order. Let this case be listed after 4 weeks.
Obliged.
Item 18. Item number 18.
None appears for the appellant on call. Mr. B.B. Gogoi, learned additional public prosecutor, appears for state respondent. It appears from record that by order dated 6/3/2020, the learned counsel for the appellant was directed to issue notice of withdrawal of wakalatnama to the appellant. However, it appears that no steps have been taken by the learned counsel in pursuant to the directions given by this court by order dated 6/3/2020. The counsel is again requested to take steps as per the directions given by this court on 6/3/2020. In the meanwhile, the registry shall also notify the appellant regarding the fact that the engaged counsel of the appellant has submitted an application for withdrawal of his wakalatnama. Let this case be listed again after 2 weeks. 4 weeks.
Item 21 and 22. It's 21 and 22.
Learned amicus curiae, Miss P. Sharma, who was appointed by this court to defend the cause of the who was appointed by this court is not present. It appears from office note dated 14/11/2023 that the case record of special POXO case number 67/2019 has been received by the registry. Let the relevant papers / paper book be furnished to the learned amicus curiae, and let this matter be listed again after 2 weeks.
Item 23. Item number 23.
Mr. B.B. Gogoi, learned additional public prosecutor representing the state of Assam is present. Mr. Kaustav Prakash Pathak, who was appointed as an amicus curiae in this case, was not found on call. Let this case be listed again after 2 weeks.
Paper book also ready.
The paper book. The paper book which is ready, a copy of paper book which has already been prepared, be furnished to the learned amicus curiae. So, the
Maybe
learned,
my lord, I'm appearing on behalf of the KP Pathak, my lord. The amicus curiae.
yes,
There's no paper has not been served upon us.
not been served. At, no, at this moment, Mr. What is your name?
B Das, my lord.
Mr. B Das appeared and appeared on behalf of Mr. KP Pathak and submitted that the paper book has not been furnished to the learned amicus curiae. The registry is directed to furnish a copy of the paper book to the amicus curiae, Mr. KP Pathak, and thereafter list this case for hearing after 4 weeks.
Sorry, I'm deeply obliged.
Item 24.
May I please, your lordship, the service is complete, your lordship. The other side has appeared, your lordship, yet and the name is appeared in a causal is complete.
You are for
The appellant, your lordship.
the appellant.
Answer is received, your lordship.
Where is the service report?
The name is shown here, your lordship.
Okay.
You Das, your lordship.
Third, Miss S. Nazneen, learned counsel for the petition, learned counsel for the appellant. None appears for respondent number 2, though name of Mr. U Das has been shown in the cause list as the counsel for respondent number 2. Mr. B. Gogoi appears for the state respondent. From the office note, whether paperwork would be required.
No.
From the office records, it appears that no, from the office note dated 8/8/23, it appears that the LCR has been received. List this case for hearing in its usual course.
Item 25.
May I please, your lordship, as per office note dated March the tax, the appellant is died, my lord.
Has died.
Yes, my lord. That superintendent jail, district jail report is there, that is marked as X, my lord. And some medical college and hospital during his treatment, my lord. So appeal is awaited, my lord, and in that case, LCR has to be sent down.
Heard Mr. M. Devi.
M. Burman.
M. Burman, sorry, M. Burman, learned amicus curiae. Also heard Mr. B.
Appellant died on 13/6/2023.
Gogoi, learned additional public
AMCH.
prosecutor. It is submitted by learned amicus curiae that the appellant in this case has expired on
It is marked as X, my lord. That report of district jail, superintendent of district jail is there in Shukia, my lord. Yellow flag
X.
mark is there, my lord. That is X. Office is also indicated the same, my lord. Yellow mark is there.
No, because this X is
Order sheet corner next. Next to the order sheet.
no, the flag, the correspondence which is marked as flag X is not the,
No, there is a line mentioned, let me see. One line is mentioned, my lord.
it's,
That flag is folded, my lord. That is
no,
why.
there are two flags with
What?
X marking. Expired on 13/6/2023. And to this effect, a report of Superintendent District Jail Tinsukia has also been received. Stop. On perusal of the said report dated 10th December 2023, it appears that the appellant Mohan Karmakar within bracket convict AC slash 1799 has expired on 13/6/2023 at Assam Medical College Hospital, Dibrugarh while undergoing treatment. Stop. In view of the demise of the appellant, this appeal stands abated. Send back the NCR to the learned trial court.
Keep clear.
Item 26.
Please, Your Lordship. Lordship, your service upon respondent number 2 is it as per office note? Article flat X, Lordship.
Heard Miss L. Devi, learned. Amicus
taking
curiae.
legal aid
Learned
counsel,
legal aid counsel, also heard Mr. B.B. Gogoi, learned additional public prosecutor. As per office note dated 29/11/2023, the service of notice on respondent number 2 has been completed. It also appears from the record that the NCR has also been received. Let this case be listed for hearing in its usual course.
Item 27. Item number 27.
None appears for the applicant on call. Let this matter be listed after 2 weeks.
Item 28.
May I please, Your Lordship? Lordship, I have not taken steps yet, Lordship. Lordship, I may be allowed to take steps, Lordship.
Take steps for issuance
As
of
per number 2, Lordship.
heard Mr. U. Chaudhary,
Lordship.
learned counsel for the petitioner, will praise for some more time for taking steps on for issuance of notice on respondent number 2. The prayer is allowed. The petitioner shall take steps for issuance of notice on respondent number 2 within a period of 7 days from the date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks.
Item 29 and 30.
May it be the worship. These two matters are lordship for cancellation of bail, lordship. I have taken 2 times steps, lordship.
Cancellation of bail.
Yes, lordship. And as per office note dated 12/12/2023, lordship. Notice has been issued upon the respondent number 223 by registered post with AD as well as through district magistrate Chirang by speed post, and then notice has been issued upon the respondent number 223 through officer in charge Amguri PS Chirang by speed post white number 13/12/2023. But neither AD card served nor notice was served. There was no report by the registry, lordship. I pray before your lordship to take instruction by the learned PP lordship from the officer in charge, whether notices were served upon them or not, lordship.
Steps through police station.
It will be next year, I think.
Yes, Mr. Gogol.
But over-
If notice served through police station, my lord, then we may take instruction.
There was an direction by this court for service of notice also through jurisdictional police station, which is the
Steps.
Amguri police station, lordship.
Steps গৈছে না গম পাইছা?
A to notice.
না, steps to গৈছে না নাই, already police station লৈ গৈছে না নাই?
Which is
Steps
again
লৈছে তো?
post of this
Then I will take instruction, my.
heard Miss
R Chaudhary.
R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor.
And may I pray to fix these matters on 13, lordship, in the meantime by a telephonic instruction, lordship.
This on perusal of the office note dated 7/2/2024, it appears that neither AD card nor unserved notice in respect of respondent number 2 and 3 has been received back by the registry of this court. However, the notices there is flag X. Notice code flag X.
Same case, no? Same.
No, notice could not be served. There is a report from officer in charge of Amguri police station.
Lordship, I have seen the office note dated 12/12/2023. That 7/2 I have not seen, lordship. Maybe it is in the some other paper, so I missed that office note.
We have to take.
Lordship, 2 times I have already
Now
taken
what is
step.
to be done? Because the notices which were sent through jurisdictional officer in charge of jurisdictional police station, those notices could not be served.
Perfect. These are the addresses which they furnished while filing criminal petition, lordship. On those address I have filed and through officer in charge also, lordship. So they are, lordship, fleeing away from the justice, lordship. On that ground alone, your lordship, The bail has to
No,
be
but
rejected.
first we have to ascertain whether because what was it? The notices sent to respondent number 2 and 3 by the officer in charge of jurisdictional police station, that is Amguri Police Station, also could not be served, as appears from the report dated 23/12/2023, received from the officer in charge of Amguri Police Station. The petitioner is directed to take fresh steps for issuance of notice to respondent number
Lordship, 2 times already taken.
and
Lordship.
issuance of notice to respondent number 2 and 3 by through the officer in charge of Amguri Police Station. Again, the notices shall be furnished to the registry, and registry in turn shall furnish the same to the learned additional public prosecutor, who will ensure the service of notice by the officer in charge of Amguri Police Station before next date. As the addresses available of the respondent number 2 and 3 are of are shown in places under the jurisdiction of Amguri Police Station. The officer in charge of Amguri Police Station shall give a detailed report as regards the availability of the respondent number 2 and 3 in the addresses provided in the notices, in the notice, and an endeavor shall also be made by the jurisdictional police station, officer in charge of jurisdictional police station, to inform this court about the correct address of about the present address of the respondent number 2 and 3 by a report to be furnished to this court through the additional public prosecutor before next day. Let this case be listed again on after 2 weeks attended. On 28/2/2023.
Lordship, they have filed the criminal petition page 86 on the same address, Lordship.
Let us see, I
Lordship.
have mentioned.
Lordship. Second
On-
one, same, out of same FIR, 7 persons were charge sheeted. 2, Lordship, in criminal revision petition 360 and 359, other 5 persons, Lordship.
Next case. No, there are 2 criminal revision, 360 and
Yes, Lordship. 2 persons filed a criminal petition, separate criminal petition for seeking bail, and 5 persons, Lordship, together filed a criminal petition seeking bail, Lordship. But 7 persons were charge sheeted, Lordship.
same order. In place of respondent number 2 to 3, 2 and 3, mention respondent number 2 to 6.
Lordship.
Same order, same day.
Lordship.
We
Okay.
have to take steps.
May I take the steps which are lying in the file, or I have to take a fresh step?
To take fresh steps.
Okay.
Item 31.
Maybe the document, it's a criminal appeal, my lord, here is the NDPS, my lord. The paper book is also ready, my lord. My lord, may I pray a date may be fixed, because my lord, here, my lord, what happened, my lord? 10 bottles, my lord, 10 years punishment. my lord. Sorry, my lord,
No,
11 bottles.
why it has come in order column?
Well, actually, IA is there, my lord, for a bail application, my lord,
I
for bail, my lord.
you are not pressing the.
I am pressing, my lord, but I think it's better to dispose of the case, my lord.
No, case is ready, paper book also ready, so it may be fixed, that may be fixed for final disposal.
Or
Hearing,
you have, if your lordship pleases to take up the bail, my lord.
You are not hopeful of getting bail.
My lord, it's a commercial quantity, my lord. Only, my lord, there are 4 witnesses, my lord.
No, then let us take it together.
Yes, my lord, that's why, my lord.
What is your submission?
Yeah, a short date, my lord.
But this is 23 matter.
Yes, well, but my lord, there is every chance, my lord, every possibility, my lord, he may be acquitted, my lord. As because, my lord, there are 4 witnesses, my lord. Out of 2, my lord, their Caesar witnesses is 2, my lord, and nothing has been stated against the petitioner, my lord. Sorry, the appellant.
No, regarding appeal, expeditious hearing, you have to make separate prayer.
Well, otherwise, it's a ready, my lord. The paper book is ready.
There
my
are
lord.
many ready cases.
Yes, my lord, but as an I can make an application, that's true, my lord.
You make it. Today I am passing orders that interlocutory application shall be taken on prayer of the counsel for the petitioner. The interlocutory application shall be taken up along with the main matter. And in the main matter, you can pray for expeditious hearing. Heard Mr. N.J. Datta, learned in interlocutory application. N.J. Datta, learned counsel for the petitioner. On request of learned counsel for the petitioner, this interlocutory application shall be taken up along with the main appeal, criminal appeal number 125/2023, which is ready for hearing. Learned counsel for the petitioner intend to make a prayer, make an application for expeditious hearing of the main
criminal
appeal, which he may do so. Stop. Let this interlocutory application be listed along with the criminal appeal again for hearing in due course.
That word may not be there, my lord, due course, otherwise it will not come up, my lord.
In the meanwhile, you have to file an
I'll file, my lord. That due course, that may not be.
after 4 weeks.
Or my lord, in the end of March, my lord.
No, if before that date.
My lord,
you have to file.
Yes, my lord.
You have to file an.
My lord.
After 4 weeks.
My. I'm obliged.
There also, in criminal appeal, there is an interlocutory application also praying for suspension of sentence and grant of bail also. And here the appellant was convicted under section 376 oblique 511 for 5 years. That is for attempt to commit rape, lordship. And if your lordships take up that interlocutory application, that is interlocutory application number 531 of 2023. I have enclosed the FIR. Lordship may kindly see the genesis of the case, page 13. And relevant portion of your lordship, the vernacular of your lordship is on page 17.
You want NCR?
Because that brief is not with us, my lord.
NCR come. Yes.
Page 17 is the FIR. Lordship may kindly see.
Page 17.
17 of the interlocutory application, lordship.
Private practice.
5 years.
No, private practice.
Private also.
They are not appearing.
No.
I think police notice গৈছে এতিয়া নাম show কৰিছে নাম show নকৰিলে
Page 7.
Now regarding service of notice on respondent number 2.
That is not mandatory in 376. If it is POXO, then it is mandatory, Lordship, in case of Deepak Nayak judgment division bench.
No, here I think my lord notice already
Notice already-
duly served, my lord,
already
name
served.
shown, my lord, in the list. First list, their name shown.
Okay, but none has appeared.
Yes.
Okay. Yes, what is
Pa-
in
Page 17, your Lordship, may I kindly see the genesis of the case? How it started? May I read? সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 25/9/2017 ইংৰাজী 17 তাৰিখ ৰাতি অনুমান 8:30 বজাত আলিচিঙা চকত থকা নিম্ন পদকীয়াৰ ফাৰ্মাচী দোকানৰ পিছফালে থকা খালী কোঠাত মোৰ পত্নী আৰু পদকীয়াজন যৌন কাৰ্যত লিপ্ত থকা অৱস্থাত ৰাইজে প্ৰত্যক্ষ কৰি দুয়োজনক কাৰায়ত্ব কৰিবলৈ ধৰাত মোৰ পত্নীয়ে পলায়ন কৰে যদিও ৰাইজে পদকীয়াক কাৰায়ত্ব কৰে প্ৰকাশ থাকে যে মই শুনা মতে আজি 6 মাহ পূৰ্বৰ পৰাই মোৰ পত্নী আৰু পদকীয়াজনে ভালপোৱা মাজত কেইবাদিনো অবৈধ কৰ্মত লিপ্ত আছে so this is the FIR. So there was, from the FIR, it appears that there was a consensual relationship. And subsequently, due to pressure of her family lordship, she alleged that there was an attempt to commit rape. This is the case, lordship.
Victim নাম কি আছিলে নিভা পাল নেকি
Victim or নাম তো- Niva. And she is accused number 2 here, that victim. First, your lordship will find appellant, and number 2 in page 17.
No, in FIR she has been named as an.
Yes. That is what I am placing before your lordship, that initially she was one of the accused.
Okay.
And subsequently, just to save her skin, lordship, she stated that there was an attempt. This is the case. And her deposition, your lordship will find at page 22 from in the judgment itself. Page 22. Paragraph 6.
Page?
Page 22, paragraph 6.
Yes.
According to the prosecution case, the incident occurred in the storeroom situated behind a pharmacy at Alisinga under Dhekkiajuli police station. The victim of the case, NPW1, stated in her evidence that on the date of the incident, she was in her paternal home. So just before going further, just I'm pointing out here, Your Lordship, that in 376 cases, one thing will be common, that there wasn't a relationship, that sexual intercourse or attempt was there. But apart from that, how the incident occurred, that is relevant, because whether the evidence of the victim is reliable or not, to ascertain this aspect, Lordship, that other circumstances, how the incident occurred, that has to be seen. In the present case, the learned trial court held that although there was discrepancy as to how the incident occurred, the material, there is no contradiction. That one single line, that will be in every case, Lordship. That contradiction will not be there in any case. That is why I am pointing out that
No,
here
I have not understood you, sir.
my submission for Lordship is that in 376 cases, we have to see, Lordship, that how the incident is described in 3 stages during investigation, 164 and deposition.
By the victim.
By the victim, because the one sentence that sexual intercourse is there or attempt is there, that will be common. Apart from that, what are the other circumstances? That has to be seen. And from that, we can only ascertain that whether the victim is reliable or not. Here, the trial court admitted that there was discrepancy how the incident occurred, but stated that there was the allegation that he has committed the offense, that is there. So material contradiction is not there. Only on that ground, she was reliable. And here your lordship will find just one thing I'm again reading, first line. Stated in her evidence that on the date of incident, she was in her paternal home. At about 8:30 p.m., she went to recharge her mobile phone in her brother's shop. So here she is going to her brother's shop, which was situated near her house. The accused Sirat Ali called her from the storeroom situated behind his pharmacy. Thereupon, she went to the storeroom and the accused asked her to see something inside the storeroom. As they entered into the storeroom, the accused closed the door and attempted to commit rape upon her. The husband of the victim woman and the informant of this case, Sri Amar Pal, also stated in his evidence that on the date of incident, his wife went to her paternal house. When he received information about the incident over telephone, he went to the Alisingha Center and saw a gathering there. PW2 has also stated that his mother-in-law's house is at Alisingha Center. The brother of the victim, Sri Pradeep Kumar Shah, has stated in his evidence that the residence is at Alisingha and he owns a mobile shop. The incident occurred on 25/9/2017 at about 8:30 p.m. / 9 p.m. In front of his house, there is a godown belonging to the owner of a pharmacy situated near his house. At the time of incident, he was in his residence, but he heard a hue and cry, and when he went out, he saw the accused being cordoned off by the local people. Now, here your lordship will find that his brother PW3, his shop was situated nearby. He went only when the public raised hue and cry, not by the victim. PW4, Srimati Mamoni Ghosh, PW5, Anjali Paul 6, Bhavita Paul are resident of Alisingha, and on the date of incident, in between 7 to 8 p.m., they heard about the incident. It appears from the evidence of these witnesses that the alleged incident occurred on so at about 7 to 9 p.m. at Alisingha inside the storeroom in the backside of pharmacy. Therefore, prosecution has duly proved the time and place of occurrence. Whether the accused raped the victim. In the offense of rape, the evidence of the victim is of vital importance. In the present case, the victim Anne has stated in her evidence that on the date of incident at about 8:30 p.m., while she was proceeding to the mobile shop of her brother in order to recharge her mobile phone, the accused Sirat Ali called her from the storeroom situated behind his pharmacy. Thereupon, when the PW1 went to the room and the accused asked her to see something inside the room. As soon as PW1 entered into the room, the accused crossed the door from inside. Thereafter, he took off her wearing apparel and rubbed her face with his mouth. The accused also tried to touch her breast and proposed to have sexual intercourse with him, but the PW1 refused his proposal and raised alarm. But regarding this,
Now, the matter was ordered to be listed today. That is how it has been listed. Now, our matter is fixed on 13th. My lord, I have been charged under 201 and 2118. And as far as the other accused are concerned, the other part, 302 and all. Now, the question is, my lord, I am assailing the order by which the charge has been framed.
You are challenging the framing of
Yes.
charges.
Yes,
Okay.
because my lord, my basic case is the requisite knowledge or intention was not there because I didn't have the information. My lord, I am a Assam Land Revenue Officer. I have been posted as a ESC. I have never been given as to how to do an inquest, my lord. And my lord, we all know the scope of section 174 of CRPC. Because, my lord, I am not a civil service officer. I am a revenues officer, my lord. By virtue of being my lord, I was appointed as a circle officer. So I was asked to do the inquest.
No, the submission.
My humble submission is, my lord. I think the victim's father is the respondent number 2. So let the notice be served on next date. My appearance may be dispensed. The lordship will fix a matter date for hearing. I'll satisfy your lordships, it's not a case where I can be proceeded with. And my lord, I am charged with 201 and 218. There's got nothing to the other accused.
There's a little variation. The thing is that the three doctors are there. They were also charged under section 120B, 218 and 201. And this, the revision petitioner was charged under section 218, as the learned senior counsel has correctly said, the 218 and 201. Now, the prima facie view has been held by the honorable trial court that there are materials on record. It's a 20-page charge order, and the sufficiency of evidence and the LCR is there. Sufficiency of evidence, the weight of the evidence, entire thing cannot be considered at the stage of consideration of charge. But whatever the materials are there in the case, in the charge sheet, as well as in the prosecution papers, the charge was framed. So
Charge was framed.
Charge was framed on 28/11.
My lord, my humble submission is, I am aware of the legal position at the stage of framing of a charge, to what extent the court can go. And against the order of framing a charge, what is the scope of judicial review? Or my lord, a revisional jurisdiction. I'll satisfy your lordships. These are matters to be, my lord, there is nothing. It's not that in every case, there is no absolute proposition of law in any aspect, my lord. There are always exceptions to every rule. So I'll satisfy your lordships. Here is a case where materials taken note of by the learned trial court to frame charge against me does not constitute the offense. That is my case. So lordship will fix a short date. I'll satisfy your lordships. It will take some time.
The problem is that the trial is getting delayed and one accused person is in jail. The prime accused person is in jail since 2022. So the problem is that only because of the revision petitioner, only charge hits has to be read out before the trial. And he has to accept, whether he accepts it or he doesn't accept, the trial will begin.
My
Now,
lord, with your lordship's kind permission, can I suggest, my lord, lordship can have this matter on 22nd or 23rd?
Yeah, at an early date, may kindly be given, because 13th is the next date. 13th is the next date, only 12th is the
22nd or 23rd, my lord. I'll satisfy your lordship.
Can it be taken on 28?
20.
Because I'm primarily considered, because the fact is that I'm conducting the trial there also, and as a special PP.
But earlier two occasions, the personal appearance was dispensed with.
Yes. Personal appearance was dismissed. Only the charge has to be read out. All the accused persons have been, there are 5 accused persons, 3 doctors, 1 prime accused. He was an SSB Jawan, and the present criminal revision petitioner is
I did only the inquest, my lord.
Inquest. And how the inquest
And
was
yes,
done?
there are infirmities in the inquest report, I do admit. But my lord, I am not a civil service officer. I was never trained to do an inquest.
No, the problem lies in that I will submit when the entire thing is read. At length, I will submit.
Okay.
How the intention part can be gauzed from the
Then
facts.
let it be fixed.
On
22nd, my lord.
Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr.
D.S.
D.S. Dekar, learned counsel for the petitioner. Also heard Mr. J. A. Hassan, learned special public prosecutor. It appears from the record that the office note dated 7/2/24 mentions that the notices issued to respondent number 2 would not be served due to non-receipt of steps by the section. You have not taken steps. You have to take.
My lord, there was inadvertently, it was left out, my lord. Tomorrow itself we will take, my lord.
Non-receipt of steps by the
I think
sections.
today itself we will take, my lord.
Learned counsel for the petitioner prays for some time for taking steps. The petitioner shall take steps for issuance of notice on respondent number 2 by within 2 days from the date of this order. So that service is necessary.
That part lordship will take a call because there's a requirement of taking steps. We'll take the steps. Let the matter be fixed on 22nd, my lord.
Let this case be listed again on LCR has come.
LCR has come.
The scan copy of the LCR has been received. Let this case be listed again on 22nd February 2024
Let it be in the admission column. my lord.
in admission column. Learned senior counsel for the petitioner has also prayed for dispensing with the personal appearance of the petitioner before the trial court on 13/1/2024.
13-2, my lord.
13/2/2024. Stop, same is allowed. List this matter again on 22nd.
Lordship,
Give
my name may kindly be shown in the cause list.
The name of learned special public prosecutor, Mr. J.A. Hassan, shall be shown in the cause list against this case henceforth.
Hello.
Leave it.
But item number 14 and 15 relates to the same accused person. Your lordship, in item number 14, your lordship has released the co-accused already on bail. Your lordship will kindly look into the orders, madam. There, for example. There,
Bail application 90.
yeah. Give it from there.
Case diary is there.
Here, my lord, case diary, actually, it was in our office yesterday, my lord, court number 22, that diary is kept in this chamber of the court number 22. Otherwise, diary available.
Your lordship will kindly look into the order passed by your lordship in bail application number 78 of 2024. My lord, your lordship will first kindly take note of my initial arrest, my lord. I was first arrested in connection with Cyber PS case number 12 of 2023. Cyber PS case number 12 of 2023 on 29/11/2023. In this case, my lord, your lordship has already granted bail, my lord. Your lordship will kindly. Cyber
Date of arrest.
In the cyber case, my lord, I was arrested on 29/11/2023. In this case, I have been already granted bail. So far, this present case is concerned, my lord, I was shown arrested in this case on 8/12/2023. Today, I am 64 days in custody, my lord. God shook, my lord.
64 days from 8/12.
8/12. From 8/12, from the date of shown arrest. And from the initial date, I have been detention in jail for 73 days. There also, we have not submitted our bail bond and affidavit because I am detained in this case. So father is a sick person. We don't want to call him to the court every day, my lord.
Who is Tapas Chaudhary?
My lord, Tapas Chaudhary was also a co-accused. My lord, 3 co-accused, your lordship has granted bail. I have given the orders, my lord. Your lordship will kindly look into the orders, my lord. Same condition, my lord. Same conditions applies also to me, my lord. Only the date of arrest will be different.
His name, you see. He needs a name, he name no.
And all these 3 were named in the FIR, my lord. Your lordship, Tapas Chaudhary, Dipankar Kolita, and Khargeshwar Das, my lord. And considering the period of detention only, my lord.
Yes, Mr. Gogoi.
Yes, lordship, that more than 60 days, my lord.
The offense is
All the sections.
467, 468 main section. my lord.
what is the maximum period of
My lord, only for 467, it can go for 10 years or life. That's why, but your lordship, 64 days, the others, my lord, I have fined, my lord. They have been granted name accused, my lord.
heard Mr. B.D. Kaur, learned senior counsel assisted by Mr. Jay Singh, learned counsel for the petitioner. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Shri Sadoy Kumar Deka, who has been detained behind the bars since 8/12/2023 within bracket for last 64 days in connection with Gorsuk PS case number 325/2023 under section 120B/467/468/448 of the 447 of the Indian Penal Code. It is pertinent to mention herein that in the instant case, the petitioner has been shown arrest while he was already in custody in connection with Cyber PS case number 12/2023 since 29/4/2023. Hence, the petitioner has been detained. Hence, the petitioner has been practically detained behind the bar for last 73 days. The gist of accusation in this case is that
In your last order, your lordship has quoted the gist one.
from A, quote gist from A from bail application number 78/24, just from that. Then quote B. Then, right, it is also submitted by learned senior counsel for the petitioner that the petitioner has already been granted bail in connection with Cyber PS case number 12/2023
And Fatasi Lambari PS case number 275 of 2023.
and Fatasi Lambari PS case number
But this is the order.
Fatasi Lambari PS case number
75/2023.
2023, in which cases he was also arrested earlier. It is also submitted by learned counsel for the petitioner that the three of the co-accused of the instant case, namely Shri Tapas Chaudhary, Shri Dipankar Kalita alias Dipankar Jyoti Kalita, and Khorgeshwar Das were already granted bail by this court by order dated 11/1/2024, passed in bail applications number 78/24, 988/2024 and 87/2024 respectively. Port C from that alleged. I have considered the submissions made by learned counsel for both the parties and perused the materials available on record, including the case diary of Gorsuk PS case number 325/2023. Stop. It appears that though the petitioner has been detained behind the bar in connection with the present case for last 64 days, However, he has been detained since in connection with other case since last 73 days. No, for last 73 days from the date of his initial arrest in connection with similar cases. It also appears that the petitioner has already been granted bail in connection with the other two cases as submitted by learned counsel for the petitioner. Stop. Considering the progress made in the investigation and as well as considering the fact that the petitioner has been detained behind the bar since for last 73 days and 3 of the co-accused are already granted bail by this court, his further custodial detention does not appear to be necessary if he otherwise cooperates in the investigation. In view of above, the petitioner, namely Sadoy Kumar Deka, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2.
Statements
Above observation, this bail application is hereby disposed of.
In item number 15, only the shown arrest date will be different. Here the shown arrest date is 20/12/2023. The last 52 days in custody so far this case is concerned, my lord.
Here diary available, lordship.
So
2012-2023.
now your lordship has already granted me bail in 3 cases. So this is the last case, my lord. I have been shown arrest on 2012/2023. So far this case is concerned, I am 52 days in custody. All the sections are same except in case of 468, it will be 467 in this case. And my lord, here also co-accused have been allowed to go on bail. And I am not naming the FIR, nor there is any specific allegations by other co-accused also, my lord. Your lordship will find the FIR of this case at page 13.
In this case, co-accused are allowed to go on bail.
Yes.
Where is the bail order?
My lord, I could get only one bail order, my lord. Your lordship, when I filed this petition, my lord.
Bail application 90.
Yeah. 4199 of 2023, madam. This was an AB, my lord. Then regular bail.
Where is the order?
Other I don't have,
No,
my
where
lord.
is that order?
At page, my lord, your lordship will find at page 8. My lord, tapestry and all was also there. I could not get it. I have the orders of the anticipatory bail of the court case.
Page 8, it is not there.
I'm sorry, my lord, 28, sorry, 28. Sorry.
Yes.
Many persons arrested, my lord, also in this case, my lord. But I was shown arrest, your lordship will find from the FIR at page 13 that my name nowhere is reflected. It is specifically directed against Tapas Chaudhary.
No, what are the facts of this case?
Page 13, my lord. Short FIR, my lord, page 13.
Mr. B.D. Kumar, learned senior counsel for the petitioner, assisted by Mr. J. Singh, learned counsel for the petitioner. Also had Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Sadoy Kumar Deka, who is detained behind the bar, who has been detained behind the bar in connection with Ajara PS case number 261/2023 since 20th of December 2023 within bracket for last 52 days. Stop. It is pertinent to mention herein that in the said case, he has been shown arrest while he was already in custody in connection with Cyber PS case number 12/2023 since 29/11/2023. Stop. The gist of accusation in this case is that on 29/11/2023, one Zakir Hussain had lodged an FIR before the officer in charge of Ajara police station, inter alia, alleging that the accused persons named in the FIR within bracket 3 accused persons, namely Dhiraj Chaudhary, Gitanjali Kalita Chaudhary and Pratibha Kalita are named in the FIR. Bracket close, have presented a fake deed in the pending Ms. J case number 464/2023 entitled suit number 277/2023 at Guwahati Civil Court. It is also alleged
The said document is missing from the Guwahati Sub-Registrar's office.
the it is also alleged that there are no related documents to the said fake deed available in the Guwahati Sub-Registrar's office. Stop. Now, what is your submission in this?
My lord, I am not specifically named in the FIR. No co-accused have been implicated me, and only to prolong my detention in this case, I have been shown arrested, madam.
And who are you? You are
I'm a
extra
writer.
Extra writer, my lord.
In the
His
Sub-Registrar's
designation.
office.
Learned senior counsel for the petitioner has submitted that the petitioner is working as an extra writer in the office of the
Sub-Registrar, Kamrup Metro at Guwahati.
Sub-Register Kamrup Metro, and he has been arrested in similar other cases also, whereas he has not been specifically named in the FIR. Learned counsel for the petitioner has also submitted that considering that the petitioner has already been granted bail in other cases where he was also shown arrested. And considering the period of detention, it is prayed that the petitioner may be allowed to go on bail. On the other hand, what is your submission?
Lordship, here main accused, my lord, Dhiraj and Tapos. These two persons, my lord, I think, my lord, yet to be analyzed on bail, my lord. Then I do not know, my lord, that is not mentioned. Other two accused, my lord, those are interim, my lord, their statement already recorded. They not implicate this person, my lord.
Okay. Learned, there is nothing implicating.
No, my lord, actually, there is no such material against this person, my lord.
Learned,
Only police suspect that my lord, he may be involved, my lord.
Learned, additional public prosecutor has submitted that though there is a strong suspicion against the present applicant, however, at present, there is no implicating material against the present petitioner in the case diary. Stop. I have considered the submissions made by learned counsel for both the sides and perused the materials available on record, including the case diary of Ajara PS case number 261/2023. Considering the fact that no credible, no implicating, considering the fact that none of the co-accused have implicated the present petitioner in this case, and also considering the fact that the petitioner has already been detained behind the bar since long.
29/11/2020.
Within bracket 52 days in this case, and in fact, how many days?
73 days.
And 73 days behind the detention in total. Behind the bar in total. His
Well,
further
that
custody,
bail
his further custodial detention may not be necessary for fair completion of the investigation of Ajara PS case number 261/2023 if he otherwise cooperates in the investigation. In view of above, the above named petitioner is hereby allowed to go on bail of rupees 30,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 is with above observation, this bail application is hereby disposed of.
Deeply obliged.
16.
My lord, 115 days, my lord. Charge sheet has already been laid, my lord. Even the allegation prima facie is not against him in the FIR. Allegation is against one Nitul Deka. Last occasion LCR, scan copy of LCR was called for. So far that scan copy not received. My lord, whether, my lord, in the, no, it is neither a case under any special act, my lord. Let him prepare his defense, my lord. It is not even a case under the special act. My lord, you see, prima facie in the FIR, it appears that the main person who has done the offense is one Nitul Deka. Prima facie. I could have understood if it is some special act, NDPS or some POXCO or those. These are IPC offenses, my lord. Normally, after filing of charge sheet, people get bail in such cases.
Under what provision?
This is FIR is registered under 436, 427, 506. And charge sheet is laid under section 436, 427, 506. This is a copy of the charge sheet, certified copy. Certified copy of the charge sheet.
Heard Mr. M. Bishas, learned counsel for the petitioner, also heard Mr. B.B. Gogoi, learned additional public prosecutor. The scanned copy of the case record which was called for has not arrived. However, learned counsel for the petitioner has submitted that the petitioner has been detained behind the bar since 17/11/2023. 17/10/2023. That is for last 115 days. And charge sheet has already been laid, and therefore there may not be any justification to detain the present petitioner behind the bar as he is ready to face the trial. Stop. The gist of accusation in this case is that on 16/10/2023, one Monica Bhuya had lodged an FIR before the officer in charge of Fatasi Nambari police station, inter alia, alleging that on 15/10/2023 at about 11:30 p.m. one Rajdeen Bhuya, Nitul Deka, and the present petitioner name is, and the present petitioner along with some other person had engaged in a fighting, and thereafter Nitul Deka set the complainant's bed on fire and destroyed the household item. Learned counsel for the petitioner has submitted that the mere perusal of the FIR would show that the allegation against setting on fire of the complainant's belonging is against the co-accused Nitul Deka and not against the present petitioner. Stop. Where is the charge?
I've given it. And Nitul Deka is, has got bail, my lord. I'm told that Nitul Deka is on bail.
Learned counsel for the petitioner has also submitted that the main accused, Shri Nitul Deka, has already been granted bail
At page number 15 by your lordship. Page 150.
by this court by order dated
11/1/2024.
11/1/2024, passed in bail application number 109/2024. Stop. I have considered the submissions made by. What is your submission?
Since charges submitted and last this court was pleased to call for LCR, scan copy of your LCR. So after examining LCR, my lord, if there is no material,
Learned counsel.
otherwise, my lord, he is named in the FIR.
Learned additional public prosecutor submits that perusal of the LCR may be necessary. Stop. For consideration of the instant bail application. I have considered the submissions made by learned counsel for both the parties and have perused the materials on record. Since on perusal of the record, it appears that the petitioner has been detained, has been languishing behind the bars since last 115 days, whereas the main co-accused has already been released on bail. The perusal of the LCR is hereby dispensed with. And finding, this court finds, and in view of the fact that the petitioner is ready to face the trial, this court find no justification in detaining the present petitioner any further. In view of above, the petitioner, namely Jayanta Bishwas, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the, which is the committal court.
My lord, additional session judge FTC number 4. My lord, may kindly see.
Case
the-
has been committed.
Yes, yes. The last page, my lord, may see, the last page. Additional session judge FTC number 4, Kamrup Metro, the last page.
Satisfaction of learned additional session judge.
The last page,
Last page of
the bail application. Page 18, my lord. পয়সা বসাইছে দুই টকা বসাইছে
for the satisfaction of learned additional session judge,
within bracket FTC
FTC
number 4,
number 4,
Kamrup Metro, Guwahati.
Guwahati, with following conditions: that the petitioner shall cooperate in his trial and shall regularly appear before the trial court. Stop. The petitioner shall not directly or indirectly make any inducement, threat, or promise to any listed witnesses in this case so as to dissuade them from deposing against him in the trial pending against him.
My lord, they just indicate the, now since it has been committed, so therefore session case number 10/2024. That session case number may kindly be indicated, my lord, for
In the beginning itself, has been detained behind the bar in connection with Fatasi number PS case number 245/23, corresponding to sessions case number
10/2024, pending before additional session judge FTC number.
4, pending before the court of learned additional session judge number.
Additional session judge within bracket FTC number 4, Kamrup Metro, Guwahati.
With this observation, this bail application is hereby disposed.
I'm sure deeply obliged.
Heard Mr. A.K. Ahmed, learned additional learned counsel for the applicant. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. This application under section 389 of the Code of Criminal Procedure, 1973, has been filed by the applicant, Sairat Ali, praying for suspension of the sentence imposed on the applicant by the judgment and order dated 2/6/2023, passed in sessions case number 16/2020 by the learned additional session judge within bracket FTC, Sonitpur, Tejpur. Stop. By the said judgment, which has been impugned in the appeal, in the connected appeal, which is registered as criminal appeal number 222/2023. The applicant has been convicted under section 376, read with section 511 of the Indian Penal Code, and has been sentenced to undergo rigorous imprisonment for 5 years and to pay a fine of rupees 10,000, and in default of payment of fine to undergo further rigorous imprisonment for 6 months. Stop. The applicant has also prayed for allowing the petitioner, allowing him to go on bail during the pendency of the connected appeal. Stop. The facts relevant for consideration of the instant application is that on 26/9/2017, the husband of the victim had lodged an FIR before the officer in charge of Dekiajoli police station, inter alia, alleging that on 25/9/2017 at about 8:30 PM, some local people saw the wife of the informant and the present applicant committing an illicit act in an empty room on the backside of the pharmacy of the present applicant at Ali Singha Chowk. And when the local people tried to apprehend them, the wife of the applicant wife of the informant allowed the applicant to flee away from that place.
Wife of the informant fled away.
And no, why, sorry, not this line. When the local people tried to apprehend them, the wife of the applicant flee away from that place, and the applicant was caught there, caught by the local people. On receipt of the said FIR, Dekiajoli PS case number 4870/2017 under section 376/498 IPC was registered and investigation was initiated. Ultimately, on completion of the investigation, charge sheet was laid against the present applicant. During trial, during trial against you were on bail, or
During trial, I was on bail.
during trial, the applicant was on bail and we faced the trial remaining on bail. The charge under section 376/511 of the charges under section 376.
376.
Charge under section 376 was framed against the present applicant to which he pleaded not guilty and claimed to be tried. The prosecution side examined 8 witnesses during the trial, and the present applicant, who was also examined under section 313 CRPC, pleaded his innocence and denied the truthfulness of the testimony of prosecution witnesses. However, he declined to adduce any evidence in the defense. Ultimately, by the judgment which has been impugned in the connected appeal, the applicant has been convicted and sentenced in the manner as already described herein above. Learned counsel for the petitioner has submitted that the perusal of the FIR would show that the victim was also involved. No, that if any act has happened between the victim and the wife of the informant, it was consensual in nature. Learned counsel for the petition applicant has also submitted that there are contradiction in the testimony of the prosecution witnesses, and there is every possibility that the connected appeal which has been preferred by the present applicant may end in may be decided in favor of the present applicant. Stop. It is also submitted by the learned counsel for the petitioner that in the petition, learned counsel for the applicant that the applicant has been sentenced to a short-term imprisonment of 5 years only, and in case of such short imprisonment, it is a normal rule that when appeal is pending, the sentence should be suspended, and the rejection of the prayer for suspension is only by way of an exception. In support of his submission, learned counsel for the applicant has cited a ruling of the Supreme Court of India in Kiran Kumar versus State of MP, reported in 2001, 9 SCC 211. Stop. What is your submission? Learned,
That involvement, my lord, that is, my lord,
learned additional public prosecutor has fairly submitted that there appears to be some contradiction in the testimony of the victim, as she had stated before the investigating officer when her statement was recorded under section 161 CRPC, that she was raped by the present applicant. However, she has stated differently
164
in
and
her
my lord,
160 in her statement, which was recorded under section 164 CRPC, as well as when she deposed before the court as PW1. Stop. I have considered the submissions made by learned counsel for the parties and have perused the materials on record. The Supreme Court of India in Kiran Kumar versus State of MP, within bracket Supra, has observed as follows. Quote paragraph number 3 from the judgment. Stop. Further, considering the submissions made by learned counsel for the petitioner, at this stage, it cannot be ruled out that the connected appeal would not be decided in his favor. Stop. As the sentence imposed on the present applicant is for a very short period, and there is unlikelihood of hearing the matter at the earliest during the due to the pendency of the large number of criminal appeals in this court. In the event if the applicant is ultimately found to be innocent in the connected criminal appeal, he would certainly suffer a prejudice. He would be prejudiced. And hence, stop. In view of above, this court is of considered opinion that that during pendency of the connected criminal appeal number 222/2023, the execution of the sentence imposed on the present applicant is required to be suspended, which we hereby do, which this court hereby do. This court hereby does. Stop. The applicant is also allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of whose
Additional Session Judge, FTC, Sonitpur, Tejpur.
learned additional session judge FTC Sonitpur, Tejpur, during the pendency of the connected criminal appeal number 222/2023. Stop. With above observations, this interlocutory application is heard and disposed of. In main case, some order would be required.
Fixed for hearing in due course.
Stop. In main case, main appeal heard Mr. A. Ahmed, learned counsel for the appellant, also heard Mr. B.B. Gogoi, learned additional public prosecutor. It appears that the LCR which was called for has arrived, and this case is ready for hearing. Let this case be listed for hearing in its due course.
So one thing also that in interlocutory order that bail year also was granted that Sessions case number 16 of 2020 that may be mentioned also.
Okay,
In that order.
impugn order is passed in sessions case number 2006.
Obliged.
Item 25.
Mid-page, your lordship. Lordship, IA criminal 636/2023, lordship, for condemnation of 751 days, lordship, in preferring the connected criminal. division.
751.
Yes, lordship. The grounds I have stated in para 4 and 5, lordship.
This revision you intend to file against which order?
Against lordship, that is in the main revision petition, lordship,
Both of revision petition.
page 23. The petitioners were lordship convicted under section 354, petitioner number 1, 323, 341 IPC, and was sentenced to undergo simple imprisonment for 2 years, lordship. And under section 354 IPC.
What are the grounds? Because how many days
Lordship,
delays of 700 and
751 days, lordship. My learned friend has no objection in lordship. In the meantime, the matter was already settled in between their family members, lordship.
okay. Where have you mentioned the ground?
That's family settlement, Lordship, after receiving. notice
Grounds for delay.
Grounds 4 and 5, Lordship.
Heard Miss B. Chaudhary,
Archer.
sorry, R. Chaudhary, learned counsel for the petitioner. Also heard Mr.
J. Laskar,
J. Laskar, learned counsel for respondent number
2
2. As well as state is also party.
Yes, Lordship. One.
As well as Mr. B. B. Gogoi, learned additional public prosecutor representing respondent number 1. This application under section 5 of the Limitation Act, 1963 has been filed by the petitioners, namely Helal Uddin and Mominun Nessa,
Moimun Nessa,
Moimun Nessa,
wife of petitioner number.
wife of petitioner number 1, praying for condoning the delay in filing the connected criminal revision. It is criminal petition or criminal revision petition.
Criminal revision petition, Lordship.
Criminal revision petition by which the petitioner intend to impugn the judgment and order dated 21/12/2018 filed by passed by the
Learned Session Judge Karimganj
learned session judge Karimganj
in criminal appeal.
in criminal appeal number
01 of
01.
2016.
01/2016,
Upholding the judgment and order dated 29/12/2020.
whereby the learned session judge has upheld the judgment and order dated
29/12/2015.
29/12/2015, passed by learned subdivisional judicial magistrate Karimganj in GR case number 315/2010, whereby the present applicant, whereby the petitioner number 1 was convicted under section 354/323/341 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 2 years under section 354, 3 months under section 323, simple imprisonment for 1 month under section 341 of the Indian Penal Code. And petitioner number 2 was convicted under section 323 and 341 of the Indian Penal Code and was sentenced to undergo 3 months each under both the provisions.
Simple imprisonment 3 months for section 323 and simple imprisonment for 1 month for section 341.
Yes. 3 months for 323 and 1 month for offense under section 341 of the Indian Penal Code. Learned counsel for the petitioner has submitted that for the reasons mentioned in paragraph number 4 and 5 of the delay condonation petition, the petitioner could not approach this court within the period of limitations, stopped. On the other hand, learned counsel for respondent number 2 has not opposed the prayer for condoning the delay in filing the connected criminal revision, stopped. Considering the fact that the counsel for respondents have not opposed the prayer for condoning the delay, as well as considering the fact that the grounds stated by the petitioner in paragraph number 4 and 5 of the delay condonation petition appears to be sufficient and good ground which had prevented the petitioner to approach this court within the period of limitation. The delay in preferring the connected revision petition is hereby condoned, and this interlocutory application is accordingly disposed of. Let the criminal revision petition be listed, be registered and listed after 1 week.
Be after, on Lordship 16th of February.
16th of February.
Lordship. Lordship, in item 29 and 30, Lordship has directed me to take step, Lordship, on the accused persons through officer in charge, Lordship. I have contacted the learned counsel who was conducting before the trial court, Lordship. They are regularly appearing before the trial court. So can I take any step through the court, Lordship?
No, now we have already passed order. You take steps. If the counsel, counsel appears on his own.
No, the accused are appearing before the learned trial court. They are facing the trial, Lordship.
In item number 20.
29 and 30, Lordship. So can I serve through that court, Lordship, additional session judge Bizney, Lordship?
You can, but we have already signed the order. It must have been uploaded.
I was looking for the provisions also, Lordship, as per section 64 CRPC, Lordship. There is some provision if they are not found, Lordship, that can be hanged in the place nearby their residence, Lordship.
No, but it is not a case of not finding them. They are appearing before the court, you are saying.
Lordship, but the officer in charge reported that they could not be found, Lordship.
In 64, item number?
Item number 29 and 30, Lordship. Again, the officer in charge, Lordship, again submit the same report that he could not find them, Lordship. As because after second time I have taken service, Lordship.
Record.
3 way I have seen, Lordship, section 64 of CRPC, service when person summoned cannot be found, Lordship. So there is another way that where the person summoned cannot by the exercise of due diligence be found, the summons may be served.
This you have already contradicted yourself. This is not a case where he is appearing before the trial court.
Lordship.
So his whereabouts are known. We will.
But Lordship, officer in charge, Lordship submitted report that the accused persons cannot be found, Lordship. So through bailer also he can serve notice, Lordship. I'm not aware whether any process was there that through court can we also serve, Lordship.
Look at the provision. I think it can be.
I have searched, Lordship, but I could not find, I only find that 64, 65.
No, you have to find out. You find out, then I'll help you. You find out some provision.
Lordship.
Because now I have already passed the orders.
Lordship.
I have already signed it. So if you want to take additional steps, you may mention along with the provision.
Then your Lordship will take step again upon the accused persons through officer in charge and next date
As
if
directed.
Lordship as directed, and on next date if they do not appear, then Lordship.
You come with the provision also
Lordship.
that this is the provision.
Lordship. Oblige.
Here, my lord, POSCO, my lord, so MICAS has been appointed, my lord. She needs 1 day's time, as she has told, my lord. But to be very precise, no, definitely, my lord, definitely, my lord, I like to, definitely, my lordship will accommodate her, my lord. Here, only thing is this, my lord, that 5 years, that authority, my lord, There is another one recently by the tax court, Assotus, my lord. The same principle of law, my lord.
What
It-
was the punishment?
5 years, my lord.
5
5
years
years.
only.
And age, my lord, age to be precise, my lord. The foundational.
Still let her go through the.
Exactly, my lord.
Lordship, I have not received the entire copy of the paper book. Some
Paper
pages are
book is
missing.
not here.
Some pages are missing, Lordship, and my name was also not reflected in the cause list.
Cause list, okay.
A short date may be given, Lordship.
Let her come prepared.
Exactly, my lord. I'm not that. Let it be
Huh?
on Monday, my lord. 5 years, my lord. By right, I will get it, my lord. Possibly, my lord.
Really?
And 8 months is there inside, my lord, and that too, my lord, age has not been proved by the prosecution, my lord. Lordship's own authority, my lord. Let it be, if possible, my lord.
Let it be on Tuesday.
Yes, my lord. Yeah, very much, my lord.
Heard Mr. B.K. Mahajan, learned counsel for the applicant in IA. Also heard Miss D. Saikia, learned amicus curiae. Learned amicus curiae has submitted that as some certain documents were not furnished to the petition to her by the registry, she could not prepare the case. Moreover, her name has also not been shown in the cause list. Therefore, she was unable to prepare the case today and prays for some time for preparing the case. The prayer is allowed. Let this case be listed again on 13/2/2023. The name of 24, name of Miss D. Saikia shall be shown as amicus curiae against this case henceforth in the case cause list.
Deeply obliged, Lordship.
Also heard Mr. R.R. Kaushik, learned additional.
My lord. My lord, registry will provide.
The registry will provide the documents all
Meanwhile,
to the learned amicus curiae.
my lord.
Item 46.
None appears for the petitioner on call. Let this matter be listed again after 1 week.
Item 47.
Yeah, please, your lordship. My lord, in this case, I am appearing as legal aid counsel, my lord. My lord, in this case, an appeal has been filed against the judgment and order passed by learned Session Judge Mazuli, my lord, in which case the accused person is convicted under section 326, my lord. IPC only 3 years imprisonment and in default 1 month, my lord, in default 10,000. My lord, in this case, my lord, 41 days delay, my lord.
Delay is there.
Yes, my lord, 41 days only, my lord. Because that time, my lord, the puja application was going on and I have received our documents later. So kindly, my lord, delay may be objection.
No, no, sure. That may be.
Heard
granted.
Miss I heard Miss P.B. Bordoloi, learned legal aid counsel for the applicant. Also heard Miss S.H. Bora, learned additional public prosecutor. This application under section 5 of the Limitation Act, 1963 has been filed by the applicant, praying for condoning the delay of 41 days in filing the connected criminal appeal, impugning the judgment dated 28/7/2023, whereby the applicant has been sentenced 28/7/2023, passed in Sessions case number 18/2023 by the learned Session Judge Madhuli, whereby the present applicant has been convicted under section 326 of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 10,000, and in default of payment of fine to suffer further simple imprisonment for 1 month. So learned counsel for the petitioner, learned legal aid counsel for the petitioner has submitted that she has been engaged in this case on 3rd of October 2023 by the Guwahati High Court Legal Aid Committee. And some time was taken for preparation of appeal after going through records of the case.
The vacation also going there that time, my lord. So kindly admit this petition and my lord suspension of execution.
The further reasons for delay has been mentioned in paragraph number 4 and 5 of the condonation of delay application. Stop. Learned additional public prosecutor, considering the fact that this appeal has been preferred by a legal aid counsel, does not opposes the prayer for convening the delay. Considering the submissions of learned counsel for the parties, as well as considering the reasons mentioned in paragraph number 4 and 5 of the condonation of delay petition, this court is of opinion that the reasons stated in the said paragraphs are sufficient and good reasons for condoning the delay of 41 days in filing the connected appeal. Hence, the delay is hereby condoned. And condone, stop. Let the connected criminal appeal be registered and listed again after 1 week. Give a fixed date. 2 weeks. 1 week. Listed again on 21/2/2023. This interlocutory application is accordingly disposed of.
Highly obliged. 21. My lord, 24.
21 to 24 করেন।
24.
May I please, your lordship? Lordship, here we have, I have filed, my lord, for rectification of a clerical typical of a error miss, my lord. Lordship, I will kindly have a look, my lord, the order, my lord, at page 7. The PS, Silchar PS case, it is 1687, it is 78.
In the order,
Lordship, and this one could have directed us to file an rectification petition, my lord. Accordingly, filed the this one court has granted interim protection by this of 16/11/23, my lord. And page 10 is the direction, my lord.
page 10 of
This application, bail application or order, my lord. This honorable court's order of I, my lord. The learned counsel for the petitioner submitted that there is a clerical typography error in the course title as well as in the prayer for the bail application. He may be allowed to rectify the said errors. Therefore, we have filed this I, my lord, to rectification of this. And paragraph 3 is the paragraph 3, my lord, in our I, my lord. Page 4, para 3, my lord.
what is the defect?
There is a, my lord, in Silchar PS case 1687/2022, whereas in not to having Silchar PS case 1678, my lord.
Not 8-7, it is 7-8.
Okay, okay. Heard Mr.
PK Decker.
P.K. Dekka, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. This interlocutory application has been filed by the petitioner in connection with anticipatory bail case number 3849/2023, praying for rectification of the inadvertent typographical mistake which has been crept in the cause title as well as prayer portion of the said anticipatory bail application. It is stated by it is submitted by learned counsel for the petitioner that due to inadvertence, the cause title and paragraph number 1 and 2, as well as in the prayer portion of the anticipatory bail application number 3849, the Silchar PS case number has been mentioned as 1687/2023 instead of 1678/2023. As the said mistake has crept in due to typographical mistake, typographical error, it is prayed that same may be allowed to be rectified. Learned additional public prosecutor does not opposes the prayer. Hence, the prayer is allowed. The petitioner's prayer for rectification of the cause title as well as prayer portion and paragraph number 1 and 2 of the anticipatory bail application number 3849 by substituting Silchar PS case number 1687/2023 by 1678/2023 is hereby allowed. This interlocutory application is accordingly disposed of. Let the anticipatory bail application be listed again after rectification of the error.
We are on interim.
In the meanwhile, interim order shall continue. Production list.
Extension order besides. May it please the lordship. My lord, this interlocutory application was filed seeking an extension of 10 days time, my lord. We appear before the learned trial court. Lordship will find your order at page 10, my lord, whereby lordship directed the applicants to appear within 15 days from the date of order, my lord. But due to the sudden illness of applicant number 2, my lord, they could not.
Due to sudden
illness of applicant number 2, my lord. Minoimia. Applicant number 2, my lord.
Sudden what?
Illness, my lord. He fell ill, my lord, due to viral.
Oh, ill.
Yes, my lord.
Illness. Okay.
Illness, my lord.
You could not appear.
Yes, my lord. Otherwise, everything is ready, my lord. They have also arranged bail. Papers are also ready, my lord. And it is fixed before the trial court on 23rd of this month, my lord.
Okay. Any objection?
Heard
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Ms. S.H. Bora, learned additional public prosecutor. This interlocutory application has been filed by the applicants Asab Uddin
and Minoy Ahmed.
And Minoy Ahmed, praying for extension of 10 days time to appear before learned trial court in terms of order dated 11/1/2024, passed in criminal petition number 1177/2023, as the petitioner would not appear before the learned trial court during stipulated period due to ailments. Stop. Learned additional public prosecutor does not oppose the said prayer. Hence, the prayer is allowed. The petitioners are allowed to appear before learned trial court in extended period of further 10 days from the date of this order in date of this order in pursuant to the order dated 11/1/2024 passed in criminal petition number 1177/2023 before the court of before the learned trial court.
Yes, Lordship.
Trial court.
Sure, other way also, Lordship, since 2022 on 2-3 occasions, they have failed to appear
Yes.
before the trial court. Lordship.
The anticipatory bail is pending or disposed of?
No, my lord, we have not filed any application, my lord, after that.
Okay.
We
No, okay, 10 days more
Lordship.
from the date of this order. This interlocutory application is accordingly this. Shall we give a fixed date?
My lord, it is fixed on 23rd of this month. The matter is fixed before the trial court on 23rd February, my lord. So they will appear on or before 23rd, my lord.
Then it will be more than 10 days.
So like then this next, my lord,
10 days.
Only 10
Instead
days
of-
may be granted, Lordship, because earlier occasion, many.
Or let
occasions
them
were
appear
failed
on 23rd.
Since 2022.
Let them appear on 23rd.
Lordship.
Instead of 10 days, the petitioners are directed to appear before the learned trial court on or before 23rd February 2023 in person with the order dated 11/1, that will remain same. Instead of 10 days, it is 20.
And Lordship, on 11/7/2023, NBW has been issued against.
That was converted to bailable, that finding is there, my lord. That is there. That is there. Page 10, my lord.
Okay, only till 23 we are
Yes,
extending.
that we kept in abeyance till 23, Lordship, and thereafter it may be decided. in accordance
That was
with law.
converted to bailable warrant of his, what 10,000, madam.
Okay, on that, we are not saying anything.
Right.
This criminal petition, no orders need to be passed.
No, it's already displayed.
Obliged.
Obliged. My lord, may it please the lordship, my lord, in this case, lordship was pleased to grant us the grant bail to this applicant, my lord. And certain conditions were there, my lord, may kindly peruse page 13, my lord, paragraph 7.
Page 13.
Yes, my lord, page 13 and paragraph 17, where lordship has put the conditions, my lord, for the satisfaction of the learned court below, as regards, my lord, furnishing bail bond. So in terms of lordship's order, my lord, the father of the applicant's, my lord, became one of the surety, my lord. And he furnished rupees 2 lakhs, my lord. And as regards the second surety, my lord, they have furnished bail bond, one surety, my lord, with a government servant working at Silchar, my lord. Oh, yeah, I have already have the original papers, my lord. But the learned court is not accepting, my lord, since the father is from outside and this person is working at Silchar. So they are insisting, my lord, that someone both should be from the Karimganj, my lord.
No, but what we can do that? What is your prayer in this case?
My lord, so if the direction can be issued, my lord, to accept the bail bond, my lord. I have the original, all the
No,
papers.
how we can
No,
issue
Lordship, that cannot be. Because he is hailing from
Because
different
that
state.
assessment of bail bonds is an independent function
Yes.
of the court before which you are
Move there.
placing the bail bonds.
Yes.
We cannot direct.
Otherwise, lordship, the order of the lordship is very specific, paragraph 17.
The court before which the bail bonds are produced has the right to reject it for reasons, good reasons. You may come against that rejection order,
Exactly.
Yes. Lordship.
but where is the rejection order?
That
Yes.
is, there was done, either they're accepting ballot and they're insisting to furnish different ballot, sureties. That is why, my lord, we could not find, otherwise everything paper is ready, my lord. I have all the original papers which they have prepared for submission, my lord, before the court.
No, what is your allegation? They are neither accepting nor rejecting.
My lord, they are saying that the father stood one of the bailer, my lord, for the.
No, what I am unable to understand is they cannot say. They have to either, the court has to either accept it
Yes, my lord.
Lordship,
or reject it.
Reject it.
yes,
And there has to be an order in the order sheet.
yes,
Beyond that,
Perhaps.
they cannot communicate you that
Yes.
I'm going to accept it or I'm going to reject it.
yes.
But we have been told, my lord, so that the person, father is, since the father is from Haryana, my lord.
Now I have understood.
my lord,
But how will you go for relief against the order of the court
When
unless
there
there
is
is
no-
an order? There is
Yes,
no order.
there has to be an order either.
If you not order, lordship may kindly direct in this IA to be submitted the bond and thereafter court will decide, my lord. Otherwise, my lord, in conformity with the lordship's order, we have furnished the bail bond. The papers are also, my lord. There, we have also furnished the security of a government.
Have you made a statement that the court below is neither accepting nor rejecting?
My lord,
Perhaps that statement is not there.
If that
it's
statement,
page paragraph. Page 4, my lord, para 5. Paragraph 1. Otherwise, the order is very clear, my lord. Only one local surety, a government servant residing within the state of Assam, was directed by this honorable court to sue as surety.
no, therefore you bring a rejection order, very
Yes.
clarify it.
So,
But now,
I understand, my lord.
on what basis we will pass an order?
Yes,
So the direction to, my lord, is and to pass appropriate order, that much will do, my lord.
No, we do not know. The court will say that it has not happened. What has been alleged, it has not happened
yes.
unless there is an order. You insist. What order can be passed
Yeah,
in?
move করে দিলে একটা order লাগে।
Okay. Heard. Mr. M. H. Chaudhary, learned counsel for the petitioner. Also heard also Ms. S. H. Bora, learned additional public prosecutor. This interlocutory application has been filed by the applicant Mohammed Rizwan and Mohammed Irfan Khan, who were allowed to go on bail by order dated 18/1/2023, passed by 24, passed in bail application number 3774/2023. It is submitted by learned counsel for the petitioner that when the counsel of the applicants approached the court of learned Special Judge Karimganj for submitting the bail bond, he was informed. Who informed you?
Office, my lord, they said. The office staff, my lord, they informed.
He was informed by the office of the learned Special Judge Karimganj that as the applicant belongs to state of Haryana, he might not be a
His father.
he might not be a suitable surety. And as regards the government service holder, as the salaries of the father,
Salary of the government servant was 30,000 net salary, man.
salary of the government servant who was proposed to be a bailer is too low. He may not be a suitable surety. It is also submitted that though the learned counsel for the applicant tried to convince the office of the Special Judge Karimganj to accept to place the bail bond. It has not been placed
No,
before.
ma'am, it has not been placed, ma'am.
Place the bail bond before Learned Special Judge Karimganj, same has not been done. And office did not receive the bail bonds which were submitted by the counsel for the learned counsel for the applicants. Stop. The allegations leveled against the office is a serious allegation. Let a report be called for from the office of the special judge, from the court of the Learned Special Judge Karimganj, as regards the allegations made against the office of the Learned Special Judge Karimganj regarding submission of bail bonds by the present petitioner. Let a copy of this order be sent through email to the Learned Special Judge Karimganj, seeking a report from the Learned Special Judge regarding the allegations made against the office of the Special Judge Karimganj in the petition. Let also the copy of order be, let also a copy of petition be furnished along with the copy of order. Let this case be listed again on Tuesday. No, because in some time has to be given.
On 16, Lordship, if
16.
it's possible.
16, ma'am.
On 16 for report from the
Special.
registry to take steps for sending the copy of an order along with a copy of petition to the Court of Learned Special Judge Karimganj.
Yes.
Okay.
Lordship, I'm not feeling well today.
Okay.
Can it be posted for next week if possible, Lordship? Next week, date, Lordship.
D. Sakya, Learned Amicus Curiae. Also had Miss S.H. Bora, Learned Additional Public Prosecutor. Learned Amicus Curiae has prayed for an adjournment today on the ground that she is not feeling well. She is indisposed today. Considering the ground mentioned by Learned Amicus Curiae, the prayer is allowed. Let this case be listed again on in the next week.
Next week. 15th, Lordship.
No fixed date.
Lordship.
After a week.
Deeply obliged, Lordship.
Obliged.
Item 40.
May I please, Judge? I also want adjournment today. Next week, we will discuss. It is not prepared.
Mr.
Yes.
S. Islam, Learned Amicus Curiae, who prays for an adjournment on the ground of personal difficulties.
Next
The-
week.
The prayer is allowed. Let this case be listed after a week. After a week.
Obliged.
Item 41 and 42.
41 and 42, my lord, Mr. K. Goswami was the amicus curiae. Lordship may change that amicus curiae now. Miss, she can be appointed. Oh, she is there. She is in the panel of the single bench. amicus curiae. This is analogous matter.
In 41-42, heard Miss S. Jahan, Learned Additional Public Prosecutor, who has pointed out that Mr. K. Goswami was appointed as amicus curiae in this case. However, he has been since elevated as a judge of this court, and therefore there is a need to appoint some other person as amicus curiae. Stop. considering the submissions made by learned counsel, learned additional public prosecutor, as well as facts of this case, Ms. D. Sakia, who is in the panel of enlisted amicus curiae, is hereby appointed as amicus curiae in these cases. The registry shall furnish a copy of paper book to the amicus curiae appointed. Let this matter be listed after 2 weeks.
Now it is 3:30 and my learned friend is ready to do Korva.
This is
We have 45 minutes left.
perhaps not take a long time because there are no eyewitnesses as such.
Okay. Or even if it takes long time, we can spill over.
Lot.
So we'll not go fast. We'll go at our own pace.
Lot.
Milord, the accused has been Milord, found to be guilty of Milord, under section 304 part 2.
Yes, sir.
Milord,
Yes.
Milord, he has been Milord, sentenced to 7 years of Milord RI and a fine of 2,000 Milord.
The punishment is?
Milord, 7 years Milord. And a fine of rupees 2,000. And in
You are
default,
sentenced under section 304.
304 part 2 Milord. The allegation is that, my lord, the petitioner had killed his father, my lord. Appellant had killed his father. And my lord, an FIR, lordship will find at page 3, was lodged by, my lord, his sister, my lord. Alleging, my lord, that at around 8 p.m. yesterday, an altercation took place between my father, Sri Bolin Bora, and my elder brother, Hamtai Bora. Later, my brother caused grievous injury to my father by assaulting him with an axe with blunt weapon with the intention of killing him. My father was immediately taken to Dhemaji Civil Hospital and treated there. But he, in fact, died there, subsequently in the hospital. Accordingly, my lord,
Yes.
my lord, the following charges for free, my lord. That on 29/3/2009 at about 8 p.m., page 5, my lord, at village Barauti and the Silapatha police station inflicted injury on your father, Bolin Bora, by means of an axe, with such intention and under circumstances that if that act by you had caused the death of your father, Bolin Bora, you would have been held guilty of murder. And thereby you have committed an offence under section 307 IPC and within my cognizance. Secondly, that on the same day, time and place, you inflicted injury on your father, Bolin Bora, by means of an axe with intent to cause him death. And as a result, during the treatment in hospital, he died. Thereby you committed an offence under section 302 IPC and within my cognizance. Now, my lord, in this case, my lord, the witnesses, my lord, there are, my lord, 6 witnesses, the IO, my lord, and the doctor, my lord. And my lord, witness PW number 1, my lord, is one Hulu Saikia, my lord. Now, all these are hearsay evidences, my lord, in fact. I know the accused. His house is near mine. The incident took place a couple of years ago. Hearing that somebody had killed the father of the accused, I went to his house. At the time, police came to the house of the accused. On behalf of the police, I put my signature on the paper.
Exhibit 1 is the said paper, scissor list. Exhibit 1 is my signature. I do not know the contents of the paper on which I put the signature. I did not see the seized materials.
What was seized?
My lord, an X, my lord.
Okay.
An X was seized. Now, my lord, PW2, my lord, is one Prabhat Soikia. He said, my lord, that page 10, I know the accused. I knew this is Bolin Bora. The incident took place a couple of years back. I had from some minor children that the accused had killed his father by assaulting him with an axe. When police came to the house of the accused, I was present there. Police seized an axe. I put my signature on exhibit 1. This is a list. Exhibit 1, 2 is my signature. I won't be able to recognize the axe if I see the same. Now, my lord, PW3 is one. PW3 is one Krishnakanto Hoikia. Accused Baba Bora and the informant Junmoni Bora are my relatives. The incident took place about 6 years back. Junmoni Bora informed me that a quarrel had taken place between Baba Bora and his father Bolin Bora. Bolin Bora sustained injuries. I asked to take him to Dhemaji Civil Hospital for treatment. Bolin Bora was my jetheri, my brother-in-law, here wife's elder brother. I took him to Dhemaji Civil Hospital and got him admitted there. On the following day, I came to know that injured Bolin Bora had died. Later, Junmoni lodged an FIR in connection with the incident. I did not witness that occurrence. I did not ask Bolin Bora about the occurrence. Then, my lord, Junmoni Bora, my lord, she is the, my lord, she's also, my lord, her evidence, my lord, is the only evidence, my lord, perhaps, my lord, which has to be looked into, my lord, basically, my lord.
She is the eyewitness.
She is not the eyewitness, my lord. She said, my lord, that's important. Accused Baba Bora is my elder brother. Deceased Bolin Bora was my father. The incident took place about 6 years back. At around 8 p.m., upon hearing the cries of my father, I came out. I saw my father in an injured state. On being asked, this is what stated. My father said that my elder brother had caused injury to him. My father was taken to the hospital. Krishnakanto Soikia is my peha, husband of father's sister. I informed him of the occurrence. He went to the hospital with my father. My father died at Dhemaji Civil Hospital that night itself. I lodged an FIR with the police station in connection with the incident. Ezahar 2 is the exhibit 2 is the Ezahar, wherein exhibit 2.1 is my signature. Police recorded my statement. In connection with the occurrence, police seized the axe by means of which injury was caused to my father. Exhibit 1 is a scissor list where exhibit 1.3 is my signature. Exhibit 1 is a seized axe which I have seen in the court today. In my statement for the police, I stated about my father telling me that Baba Bora had caused injury to him, had caused injury to him. It is not a fact that I have adduced false evidence. It is not a fact that the accused did not inflict injuries to my father with a seized axe. I put my exhibit 1.3 signature at home. Then one of the policemen. On 3/3/2009, I was posted as Sipaldhar Hilapathar PS as ASI police. On that day, OC received an Ezahar from one Junmoni Bora to the effect that the accused Baba Bora and Elias Khumtai had assaulted her father, causing grievous injury in his person. Accordingly, OC registered a case number so-and-so and entrusted me for preliminary investigation. The injured received treatment at Hilapathar PHC, and thereafter he was referred to Dhemaji Civil Hospital. I took up investigation on 3/3/2009 at 10:30 AM. However, the injury was taken to hospital immediately after the incident. During the investigation, I recorded the 161 statement of the complainant Junmoni Bora. Thereafter, I visited the place of occurrence. I prepared a sketch map. I seized an axe from the accused Baba Bora. I recorded the statement of the witnesses of the PO. The accused, who when examined under section 161 CRPC, confessed to have committed the offense. The accused was arrested and application was made for this court for recording the confessional statement of the accused. During investigation, the injured died, and as such, I made prayer before the learned CGM Dhemaji to add section 302 against the accused. The injured Bolin Bora died on 3/3/2009 at about 10:30 PM at the Dhemaji Civil Hospital, and on getting information regarding the death of Bolin Bora, OC Dhemaji PS entrusted SI Durgeshwar Gogoi to hold inquest on the body. Accordingly, Durgeshwar Gogoi had an inquest and issued a challan for post-mortem examination. On my transfer, I handed over the case diary to OC on 1859. SI Kulodhar Kumar collected PM report and on completed the investigation, submitted charge sheet.
against the accused Baba Bora Kuntai to stand trial under 302 IPC. Exhibit 3.1 is a sketch map. 3.1 is my signature. Exhibit 1 is a scissor list. Exhibit 1.4 is my signature. Exhibit 1 is the seized acts which I have seen in the court. Exhibit 4 charge sheet. Exhibit 4.1 is the signature of Kulodhar Kumar, which I know. During the cross, the accused stated before me that his age at the time of arrest was about 26 years. I went to the PO on 30/3/2009 at about 11 a.m. I have not recorded the statement of the neighboring persons of the PO mentioned in the sketch map. Immediately after the incident, the injured was taken to hospital by family members, but I have not visited hospital, not collected any document in respect of his treatment in the hospital. I recorded the statement of the complainant after the incident on 30/3/2009 before the death of the deceased. However, after the death of the deceased, I did not record the statement of the complainant. I recorded statement of witness Krishnakanta Soiki after the death of injured Borin Bora. It is not a fact that I did not seize the weapon of offense X on being produced by the accused. I have not seen the weapon of offense to FSL, not send the weapon of offense to FSL. I have not recorded the statement of SI Durgeswar Gogoi. It's not a fact that I have not made an investigation properly. It's not a fact that the accused made confessional statement before me under duress. Then, my lord, the Dr. Miller, on so-and-so, I was posted to the Himalayan Civil Hospital on that day on police requisition by so-and-so. Performed post-mortem examination of the dead body of the Borin Bora male, about 50 years. It was identified by Moniram Dwara. An examination found as follows. External appearance, there is a lacerated wound over both parietal bone, size about 3 inch into 2 inch. Cranium and spinal canal, after opening of the scalp, there is a hematoma under the wounded area of a 4 inch to 2 inch. With a repressed fracture in the right parietal bone. Under this parietal bone of hematoma, 4 into 3 inch size found in the right parietal brain matter. Spinal canal, thorax, abdomen, and other organs are normal. According to postmortem examination, the cause of death is neurogenic shock. Exhibit 5 is the postmortem report. 5.1 is my signature. I have not mentioned the time of death of the deceased in my report. Now, my lord, in his 313 statements, my lord, he has denied, my lord, the statements, my lord, saying that all these are false, my lord. And he claims that he is innocent and he did not kill his father. Now, my lord, lordship will see from the evidences, my lord. I just place, my lord, the Caesar list, my lord, once more. The Caesar list, lordship will find, my lord, at page 36. An axe fitted to a bamboo handle measuring so and so. The bamboo handle has 3 knots. The iron portion has about 7 inches long. SD Kumtai Bora. This signature has not been proved, my lord. This has not been exhibited, not been marked as exhibit, not proved. Then Bulu Soikia, my lord. She is she stated, my lord, that she doesn't, my lord, remember. He will not be able to identify the ex, my lord. And lordship sees, my lord, the evidences, my lord. There is nothing in the evidence of, my lord, Bulu Soikia saying that, my lord, the X was recovered, my lord, at the instance of, my lord, the accused, my lord. Bulu Soikia's evidence, lordship will find PW1 at page 8. He says that he doesn't know what are the contents of the paper where he had put his signature, and he did not see the seized materials. But he was there when the police came, my lord. So, my lord, this Caesar witness, my lord, he denied, my lord, having seen the, my lord, X, in fact, my lord, the seized weapon, first of all, my lord. There is no statement to the effect that, my lord, the police had seized the, my lord, weapon on being shown by the accused. Then, my lord, PW, my lord, 2, my lord, is of course not a, my lord. Yes, put PW2 is there, my lord. PW2 is Prabhat Saikia, my lord. He is also, my lord. He also said the police seized an X, but it was not, there is no statement, my lord, that it was seized as that, my lord, on being shown by the accused, my lord. PW2, my lord. He also did not say, my lord, that. So far as the PW3, my lord, PW, my lord, 4 is concerned, my lord, the informant, my lord. In fact, in her statement also, my lord, though it is stated that the police had seized the X, my lord, but there is nothing to show, my lord, that it was seized at the instance of the accused, my lord. There was no statement made to the effect, my lord, that he led the police to the, my lord, weapon, my lord, and was seized by him, my lord. Though the police, my lord, the investigating officer, my lord.
Is it their case that it was seized at the instance of the accused.
The police, my lord, investigating officer, he made a statement, my lord, that he had led this to my lord. That is it, my lord, I read, my lord. That is,
W5.
yes, my lord, I prepared a sketch, my lord. My lord, about my lord, at the bottom, my lord, sorry, in middle, my lord, page 16, I prepared a sketch map about, my lord, 1, 2, 3, 6, 7, 8, about 9 lines, my lord, from the top, my lord. I prepared a sketch map. I seized an X from accused Baba Bora. I recorded the statement of the witness as the PO.
On being produced, not led.
There is no 27,
There is no 27.
not 27.
No, really. You know, my lord, this, he said that, or my lord, from the accused, my lord.
The only evidence is that the daughter says that father told her.
Father told her, that's the only.
Before
Nobody
dying.
brought us evidence.
Yes.
That's the
Only
only.
oral dying declaration, but prudence requires that there has to be some corroboration, oral dying declaration. So corroboration is like the other boy said that there was a fight in between them and he heard from inside. And otherwise corroboration,
Before you start, let him finish.
a lot should be.
There is no statement, my lord, by the Junmuni Bora, my lord, saying that the accused was present at that point of time. There's nothing to show that the accused was present and he will.
No. But the statement is that her father
Father had
told
told
her
her. That's what she said, my
that-
lord. That's what she said. But then, my lord, there is nothing, there is no statement, my lord, that my lord, there is no statement to show, my lord, that the accused was present at that point of time, my lord, in the house, my lord. And he was the only person, my lord, who could have, my lord, done the offense, committed the offense. That is the first prerequisite, my lord, for us in my humble submission, my lord, that it has to be shown, my lord, that the accused was also present. My lord. There was no other hypothesis possible, my lord. There was no other person, my lord, there, my lord, who could have, my lord, committed the act, my lord. And it is only her statement that her father had, my lord, said, told him, my lord, told her that the son had, my lord, caused injuries to him, my lord. That is the only evidence, my lord, there, my lord.
So now the question is that whether that statement in itself is sufficient to
Exactly.
hold the
My lord.
appellant guilty.
My lord. In fact, my lord, if I may assume for a moment, my lord, that this statement, my lord, was, my lord, used against him, my lord. Or for that matter, why would she lie, my lord? That question might arise. But that question was not put to him under 330. That ought to have been put to him, my lord, because that was a circumstance then, my lord, as to why she would lie. Because otherwise, my lord, he had no reason not to answer. I mean, he could have then answered the question, my lord, why she would have lied or she had made that statement. That perhaps is also not there. Well, furthermore, my lord, there is nothing to show, my lord, there was a previous, my lord, quarrel or animosity, my lord, nothing on record, my lord, to show, my lord, either in the FIR, my lord, or for that matter, my lord, in the evidences that there was some, my lord, existing quarrel between the father and the son, my lord, which led to, my lord, this occurrence, my lord. No, question was asked, but it was not asked as to whether why she would lie or why she would make a statement against him. It was asked that Junmuni said so and so. She said false evidence. But it was important that he ought to have been given to explain if that is taken into account, that why would she lie? Of course, that was not the finding of the learned court, my lord, that going to that aspect. But if that is there, my lord, why, if that is to be relied upon, my lord, why should not lie, or why should lie because about her father's death? Well, that question ought to have been put. Perhaps then you could have explained, my lord, if we had there was some explanation could have been there, my lord. But that was not asked. So, my lord, therefore, my lord, only thing, my lord, and my lord, then my lord, lordship will see, my lord, that the evidences on record. I mean, sorry, the learned single judges, learned trial court's order, my lord. That, my lord, page starts at page 25, my lord. My lord, he presumes certain things, my lord. My lord, I'll read from the point of determination, my lord. That on 23/9/2009, at about 8 p.m. at village so-and-so, under so-and-so, inflicted injury in the father Bolin Bora by means of an X with such intention and under such circumstances that of the act you had caused the death of your father so-and-so, you would have been guilty of murder and thereby committed offense punishable section 307. That on the same day, time and place, you inflicted injury on your father, Bolin Bora, by means of an X with an intent to cause him death. And as a result, during his state treatment at hospital, he died, and thereby you committed punishment and committed and punishable under section 302 IPC. I've gone through the evidence of record and heard submission to advance land council both sides. PW1, Bulu Saikia, in identify the accused in the dock. He deposed that the occurrence took place about a few years back on the relevant
Where are
date.
you reading?
Page 26, my lord.
Okay, we can skip this because we have already gone through.
My lord. You can see it. Appreciation of evidences, my lord. Page 29, my lord.
Yes.
From the discussion of the evidences on record, it appears the prosecution has examined 6 witnesses, including the MO and IO. PW4 is the complainant. According to PW4, she is the younger sister of the accused and deceased Bolin Bora was her father. According to PW4, on the date of occurrence at about 8 p.m., on hearing the cries of her father, she came out of her house and she saw her father in an injured condition. On being asked, her father told her that the accused, her brother, had inflicted injury on him. The injured was taken to Dhemaji Civil Hospital, where he succumbed to the injuries. The PW1, 2, and 3 are all non-official witnesses. They stated that on the relevant date on hearing about the death of deceased Bolin Bora, they went to his house and came to know that the deceased son, Baba Bora, had killed his father. There was a quarrel between the accused and his father, and they heard that accused had killed his father. That quarrel part, was nowhere there. No one said anything about any quarrel. Only thing they said was they heard that he had killed his father. From the evidence of the IO, it is seen that the IO, PW5 of the 5, on the receipt of Ejahar, a case was registered, and during investigation, the IO visited the PO and drew a sketch map and recorded statement of witnesses. He also stated that the injured was first treated at Hilapatha PHC, and thereafter he was referred to the Dhemaji Civil Hospital. Initially, a case was registered under Section 307 IPC, and during the investigation, the injured died and Section 302 was added. Inquest was held on the dead body and postmortem was done, and the IO also sees an axe from the accused. Now, there is no witness except for the statement of the IO. There is no statement that the weapon was seized from the accused. The medical evidences show that there were depressed fracture in right parietal bone. A hematoma of 4 inches with 3 inches size was found in the right parietal brain matter. The doctor obtained the cause of his neurogenic shock. Doctor also found external injuries of a parietal bone. In the instant case, admittedly, there was no eyewitness to the occurrence. Hence, the case rests on circumstantial evidences. I may enumerate the circumstances brought on record by the prosecution side, which are as follows. That the accused and the deceased were son and father respectively were at a home at that relevant point of time. This is totally without any evidence. There is no evidence that the accused and his father were at home. There was a quarrel between the two at the relevant time. That is also not there. Police seized the axe from the position of the accused, but that is not corroborated by any of the witnesses. Deceased certain fractures on parietal bone as per medical report, which supports oral testimony of PW. Medical evidence shows the deceased died as a result of sustained injuries. Before I further analyze the facts and materials of the facts and circumstances, the materials on record, I may reproduce the principles laid by the Honorable Supreme Court in regard
He
to
has not mentioned the main circumstance. The father telling her daughter that your brother has assaulted me. That circumstances he has not. That is one of the circumstances.
That is the only circumstance. That is the only thing that is there. In the circumstances, the conclusion the guilt is withdrawn should be fully established. The circumstances concerned must or should and may not be established. The facts established should be consistent not only with the hypothesis of the guilt of the accused. That is to say, there should not be explainable or any other hypothesis except the accused of the guilt. The circumstances should be of conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved. The chain of evidences is so complete not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probable death must have been done by the accused. In the instant case on scrutiny of the evidence record, it is quite evident that there was a fight between the accused and the deceased. And the deceased sustained injuries and was taken to hospital where he died. It is quite clear from his evidence that the police seized weapon of offense from the accused. None of these are corroborated with the evidence. Any evidence is there, in fact. It may be noted here that there is absolutely nothing on record to show that a third-party process is involved in the commission of offense. The medical offense also supported the injury sustained by the deceased due to assault by the axe. So it can be safely concluded the circumstances brought on record by the prosecution side to the effect that the accused assaulted his father, resulting in his death, has been fully established. The facts so established are consistent with the hypothesis of the guilt of the accused and is the conclusive nature and tendency. Further, the chain of evidence is so complete that it hardly leaves any reasonable ground for the collusion consistent with the innocence of the accused, and it may be concluded in all probability death has been caused by the accused. I've seen from the record the accused was examined on 313, simply denied his involvement, although he was present at his house with his father. No, this is totally, my lord, out of, without based on no materials, my lord. He did not make a statement as to how his father has sustained injuries in his presence or any other examination in this regard. Now let me see whether the death caused by the accused constituted murder under defined as section 300 IPC, punishable with 302, or culpable homicide not amounting to murder, as defined under section 299 IPC, punishable under section 304. The following comparative statement shall be useful to elucidate the points of distinction. Well, he has distinguished the points by the sections. Well, in the instant case, it is found that there is a fight between the accused and the deceased, and they being father and son must have some issues between them for which the occurrence took place. Well, totally, my lord, totally out of, my lord, has got no connection with any evidence recorded. Well, however, fact remains the accused assaulting him with an axe causing injury is a grievous nature, which ultimately resulted in the death of his father. From the circumstances enumerated it can be safely concluded the accused caused the death of his father without premeditation, in the heat of passion, and with an intention to cause death. However, it is quite clear from materials on record that the act was done with the knowledge that is likely to cause death. Hence, I find that the case comes under exception 4 to the 300 IPC. It may mention here that the accused caused death of his father by assaulting him with an axe. It is found from the materials on record that the deceased died as a result of the injuries inflicted on him by the accused. It is that the police initially registered a case in the so-and-so, and deceased was sent to hospital and he died. And then the police added section 302. The police finally submitted charge sheet under section 302 IPC. Since we find that the case of culpable homicide not amounting to murder is made out of causing death without intention and premeditation on part of the accused, punishable in section 304 part 2, I find ingredients section 307 are not reflected. So far as having, so far as regard the law and facts and circumstances enumerated on the opinion, there's a case under section 304 part 2 is established against the accused. 304 reads as follows. In view of what we discussed, I find the prosecution has been able to prove offense under section 304 part 2 against the accused Baba Kumtai alias Kumtai Bora beyond all reasonable doubt. Prosecution has failed to prove the charge under section 307. And my lord, then the final, my lord, pronouncement. My lord, here, my lord, specific defense, no, my lord, if specific defense has not been taken, my lord, that cannot be a ground, my lord. It is to, the prosecution has to stand in its own legs, my lord, and has to, my lord, prove the, my lord, murder, my lord, beyond, my lord, or prove the incident, my lord, beyond all reasonable doubt, my lord. And here, one of the ground that has been taken, my lord, that he has simply denied his involvement, my lord, without, my lord, going any further. That per se, my lord, cannot be, my lord, ground, my lord, to really disbelieve or, my lord, to hold him guilty, my lord, unless, my lord, disproved, my lord, by materials on record that he had indeed killed his father, my lord. And as the lordship has seen, my lord, most of the things, circumstances they've been taken into consideration, my lord, are all surmises and conjectures, my lord. The learned court below, my lord, thought, my lord, this has happened, that had happened, my lord, and accordingly, my lord, which is true.
Okay, why to disbelieve the testimony of
PW4? That's true, my lord. But then my submission, my lord, that question was even not asked, my lord. That odd question ought to be in court, my lord. That why your sister would lie. It would have given him a reason to explain. That was also not done, my lord. So that unless that circumstance is brought before him, my lord, and he's given to, my lord, explain that situation, my lord, that cannot be relied upon, my lord. And as the lordship has seen, my lord, in this particular case, my lord, this particular aspect has not at all been, my lord, taken into consideration by the court below, my lord. He had, my lord, presumed, my lord, there was a fight between the father and my lord, son, my lord. He had presumed, my lord, that they were there at the home, my lord, everything, my lord. But that aspect, my lord, was not even asked, my lord, not even, my lord, discussed even.
Okay.
So the first thing that ought to have proved, my lord, is that he was there, my lord, and there is no other hypothesis, no one could have killed, my lord. That hypothesis ought to have been there.
Okay, Ms. Jahan completed.
In fact, I've
Anything?
checked. Yes, only the oral dying declaration is the evidence here.
Whether it can be the sole basis of.
Whether no, I've got a judgment of Supreme Court saying that oral dying declaration prudence requires corroboration. So corroboration again is I don't find any because it was PW5 only who said that there was a quarrel. And in the FIR, that too by 5. Quarrel.
She also did not say about quarrel. She only said, my lord, that she heard hue and cry and came out with father so her father. But she didn't say about the quarrel, my lord. She
No,
was,
she said they were fighting.
no, she said I heard hue and cry.
I heard hue and cries.
And then came out.
I saw my father.
In an
Acha.
injured state.
PW4 said, Krishna Kanta said that Junmani had informed him that
Yes.
there was a quarrel.
But Junmani herself has not stated.
Not
that.
said.
About quarrel. Junmani simply said, heard hue and cry. She came out and she saw. In fact, I checked her 161 statement. There it seems she was an eyewitness. She heard hue and cry. She came out and she saw the brother hitting her father. She in fact separated them. That was her statement. No dying declaration in her 161 statement. But then this contradiction was
There
not
was no
proved.
dying declaration.
There was no oral dying declaration in her 161. But
it
that was not
put-
brought. Not contradicted. Now we cannot go to 161 statement. It should have been brought by defense. Not brought. No, the oral dying declaration which cannot be the sole basis unless there is corroboration. Corroboration is hardly there. Even his presence, nobody has said that I saw him at the place of occurrence. Perhaps inadvertently or I don't know, to save him. Because that judgment I can place that which requires prudence requires corroboration. 97, that is
Give the citation.
take some time in taking it out.
Given citation.
No, I had that judgment. But it is 97 something.
There is a provision that aid of case diary can be taken during trial.
During trial, but in appellate stage,
That is is it a continuation of trial? Now, how that aid is to be taken?
that of course, as your lordship was
Great.
there in the division bench, we are yet to see it.
How?
But 161 in the trial, unless for contradiction, we cannot see at all. It is only for
161
contradiction.
cannot be basis of arriving at it,
No, not at all.
except contradiction.
Only contradiction. Otherwise, it's a waste paper. As my lord, Sridhar Rao used to say. It's a waste paper. Unless contradiction, nothing. In fact, the judgment on prudence requires corroboration. Had that.
So even if in
Gotcha.
161 statement, a totally contradictory statement has been given by the a witness, which was not contradicted during trial. And even if it comes to the notice of trial court, it cannot take into consideration that 160.
No, it has a court could have put question if it has come to the notice of the trial court to the witness, but cannot
Under
take it.
165.
But cannot take it as it is. I cannot rely on those.
You may give me later on also.
Lordship. In fact, it was written and I'm getting it.
Heard,
Lordship.
Mr. M. Doctor.
Yes, I got it, Lordship. Now, this is 99-8 SCC 458. Oral dying declaration. As a matter of prudence, corroboration is required. 99-8 SCC 458. Paragraph I have not written. Yes, I Supreme today, no? 99-8 SCC.
99, no? 99, 8, SCC, page
458.
458.
Hekkerism, Anubhav Singh versus State of Manipur.
State of Manipur.
There it is written, dying declaration.
Available to function.
Oral dying declaration can form the basis, though the court seek for corroboration as a rule of prudence. It can form, it can be basis, but again, we cannot lose sight of the fact that 161 she did not share.
Heard, Mr. M. Doctor, learned amicus curiae. Also of Ms. S. Jahan, learned additional public prosecutor. Hearing concluded, judgment reserved.
Lordship. Deeply obliged, Lordship.
Any other item? One more item is there?
No.
Anything?
May it please the Lordship. Lordship, I beg to mention item number 36, Lordship. Lordship, I apologize, Lordship. A matter was going on in court number 13. I was appearing in that matter, my lord. My lord, an
Okay.
order was
You are
passed.
for?
My lord, for the petitioner, my lord.
Okay, you're
For the petitioner, my lord, as per office note dated 5th of February 2024, my lord. Neither the
item number 36 or dictation, Luisenia. Okay, sure. Your appearance will be shown.
yes, Lordship.
It
Lordship.
is to be,
Lordship, as per office note dated 5th of February, my lord, notice has been served and has been served but has not been received back, my lord. My lord, we have taken steps twice, my lord. My lord, they are delaying the process, my lord, the respondent, my lord. My lord, we have some urgency, man. In the meantime, my lord, the interim pay may be, my lord, considered, my lord, for the time being, my lord.
36 file purpose. No, now we are showing only your presence. And after 1 week, we will consider your submission.
Yes, Lord.
Okay.
This person has not come.